Now it is my pleasure to invite the President of Pertubuhan Architect Malaysia, Architect Adrianta Aziz, to deliver the opening remarks. May I respectfully invite the President to the rostrum.
Strengthening arbitration frameworks to support fairness, efficiency, and industry confidence. Distinguished speakers, members of PAM, PAM Honorary Secretary, Architect Anthony Lee, PAM arbitrators, ladies and gentlemen. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera, selamat pagi, good morning, Chow San, Kale Vanakkam, Salam Malaysia Madani. And a very warm welcome to PAM Centre. On behalf of Pertubuhan Architect Malaysia, PAM, I am pleased to welcome all of you to today's ADR forum, the way forward for PAM construction arbitration, raising the bar. Thank you for taking the time to be with us today, a beautiful Saturday morning. And ladies and gentlemen, arbitration has long been an integral part of the PAM standard forms of building contracts. For decades, PAM arbitration has served the construction industry by helping parties resolve disputes in a fair, balanced, and practical manner. It has played an important role in maintaining professional confidence and contractual certainty within our built environment. However, the construction industry today is no longer what it was before. Projects has become increasingly complex. Disputes are more technical, more demanding, and often more urgent. Parties now expect disputes to be resolved faster and, of course, at a lower cost and with a greater efficiency. As this expectation evolved, PAM must also continue to improve and adapt. So in this regard, PAM has recently approved amendment to the PAM Arbitration Rules 2025, which are expected to come into force later this year. And these amendments are timely and necessary. They include provisions for lump sum arbitrations and expedite procedures for disputes below 1 million ringgit Malaysia, and other suitable cases, as well as the new provision empowering the PAM presidents to determine the arbitrator's fees by reference to fee schedules and of others arbitral institutions, where parties are unable to agree on fees within 28 days from the appointment of the arbitrator. And these changes, ladies and gentlemen, are intended to enhance certainty, efficiency, and confidence in PAM administrated arbitrations while ensuring that the process remains fair and credible for all parties involved. So, ladies and gentlemen, today's forum is organized for one simple reason: to discuss how PAM arbitration can be done better. This is not an academic exercise. It is a practical conversation about how arbitrations are conducted, how unnecessary delays can be avoided, and how decisions can be delivered clearly, fairly, and effectively. So we are honored to have with us a distinguished panel of speakers and a moderator. Please give an applause to Datuk Mary Lim Tiam San, President AIAC Court of Arbitration. Welcome, Datuk. Tan Sri Datuk Panglima David Wong Dok Wah. Welcome. Chairman, Borneo International Centre for Arbitration and Mediation, BICAM. Madam CIPAA Selvaratnam, welcome, Madam, Independent Arbitrator. Mr. Chan Keng Ho, yeah, our advocate and solicitor. And my good friend here, Architect Kebi Tiong, PAM Arbitrator. Welcome. So their profiles and, of course, the program are outlined in the forum flyer. I will therefore not go through their backgrounds in detail. And I would, however, like to express our sincere appreciation to all our speakers that I mentioned and moderator for sharing their experience and insight with us today. And ladies and gentlemen, I will also like to thank our sponsors for their generous support in making this forum possible. HLP, Harold and Lamb Partnership, please give a round of applause. Thank you so much, HLP. Tommy Thomas, Synergy, Be Asia Pacific and Trustee, and also Azman, David and Co. Give a round of applause to our sponsor. Thank you so much. Ladies and gentlemen, PAM remains firmly committed to strengthening its arbitration system through better rules, improved administration, and continuous learning by our arbitrators and users. We hope that today's forum will be practical, constructive, and beneficial to everyone here. But unfortunately, I have to be excused myself to split my soul and body to another event after this at the Icon City to deliver my speech and facilitate a professional forum to all graduate architects to obtain their license. But I will leave my quote of the day to you all at this special today's forum. Evolving arbitration practices to meet the growing complexity of today's construction disputes. So I wish you all a fruitful and enjoyable day. Thank you so much. Give a round of applause to everyone. Welcome to PAM Centre. Thank you. Okay, Daniel.
Yes. Thank you, Mr. President. Mr. President, if you can just remain on stage for a group photo taking session. And before we proceed any further, if I could invite those office bearers and council members who are present, speakers and moderator, up to the stage for this purpose. We now move on to our keynote address, which frames the central theme of this forum, delivering justice efficiently without compromising standards. It is my honor to introduce our keynote speaker, Datuk Mary Lim Tiam Suan. Datuk Mary, yes, the floor is yours.
Good morning, ladies and gentlemen. Thank you very much, Pam, for inviting me. It's a keynote address, but I'm not too sure whether I hold the right keys or whether nowadays with AI looking after us, it's facial recognition. So perhaps it's your face that's the key. So don't look at me. As instructed, and you probably saw me going up to Daniel and exchanging a few words before stepping up here. That is exactly the problem that we all face. And that is, what's the script? What's the event? And how much time do I have? And it's a failure to obtain that script, to abide by that script, that we are all in trouble. And we have to open our doors and give the keys to somebody else to address us on what was said to be a beautiful Saturday morning, and we're all wondering why we're here and not somewhere else. Ladies and gentlemen, the topic I'm supposed to talk about is delivering justice without delay, and hopefully raise some standards here at the PAM itself, particularly in your arbitration. As instructed by Daniel, under the auspices of Anthony, I have been asked to speak about this topic from 5 respects. So what are the respects? Well, first, although he's called it issues faced by PAM, I shall draw your attention to the significance and implications of delay, before I move on to the topic of issues that are particularly faced by PAM, and then discuss, as my third issue, the measures which PAM have implemented, and then look at what your current direction and your standards may be before coming up with some forward considerations. So that's a script that I was giving, and hopefully I keep within the half an hour slot given to me. The matter of costs and delay, ladies and gentlemen, I think the first question we all have to ask is, when is delay a delay? And this must have pondered the son of a late dear friend of mine, because it caused him to open a restaurant by exactly that name, Delay No More. You may have been to that restaurant. I think he must have waited either for his meal to be served or to be even approached to be served, or for the season of crabs to arrive. Whatever it is, that moniker must have caused him to finally open a restaurant by that name, and I understand he opened a second branch. Many of you certainly must be familiar with the phrase or the adage, justice delayed is justice denied. But so is justice hurried, being justice buried. So where are we going to find that good balance? But let's stay first with justice delayed is justice denied. And it's said that once you have a judgment pronounced and there is then a resolution of the dispute or the difference between the parties, you then lend certainty. And I quote, it limits the negative externalities that are derived. And by decreasing this uncertainty, you make contractual obligations more likely to be performed. And a judiciary that functions with that ethos will ultimately contribute to investments and ultimately economic development, unquote. While it says judiciary, it actually is all of us. Delay is like a malaise. It's insidious, it certainly is destructive. It affects our present, it taints our future, and it certainly makes for a bad past. Costs, especially which are unplanned or unscheduled, they will rocket and they will compromise all other commitments, be it in terms of priority or complete relegation to obscurity. Your expansion plans and your relationships will tank. Rebuilding, ladies and gentlemen, is hard, very hard. Have you ever heard of divorce proceedings? Watch what happens to the parties and to the proceedings. It really is no different. What needs to be appreciated is that delay may be due to omissions and sometimes positive acts. Omission could be because simply there are no provisions at all to address or to guide on how to do things and to do it within what is the time frame. Positive acts are where, unfortunately, there is manipulation or abuse of procedure or process, and worse, when you're dealing with discretion. In all that, the question then is, where is justice? But let me get back to the question of when is delay. And that's not a rhetorical question to spoil your Saturday. The answers are intended to assist with the analysis, to come up with some kind of reform that will improve timeliness and user satisfaction. For clients, the customers, the users, it will facilitate planning and manage your expectation, and for all of us, whether we get return clients, and that is so important. And let me take you through some cases that took place in the last year, reported in 2 or 3 jurisdictions, and I want to ask you whether you would think that's a delay. In a case called Damley Capital, reported end of last year, certain key documents were filed late in court contrary to court directions. It cost the claimant over $400 million when the case was automatically dismissed. It was a 1-hour delay. What do you think? In Malaysia, before our 2009-2010 reforms took place, it was very commonplace to see cases taking over 5 years at the first instance level. Let's not talk about appeal. In the construction community, claims arising from delay itself in the works, it's commonplace. And here comes another decision recently decided by the Malaysian Court of Appeal, also in 2005. Parties had contracted to build office as well as a factory, and the contract was made in December of 2015. And there was supposed to be a tenancy agreement to follow in 2017. Completion was delayed by a year, LAD was imposed, parties filed claim in court in 2019 to recover the LAD plus loss of profits. Decision was given, and I noticed from the registration at the Court of Appeal, the High Court disposed that claim sometime early 2024. So claim filed in 2019, High Court disposed the dispute 2024, with 2 appeals going up in January, February of 2024. It was disposed in July 2025. I'm not sure if they're going in for another round in the federal court. From the time of contract in 2015 to the decision in 2025, I get 10 years. Is that delay in this administration of justice? Let me take you to Singapore in a decision called Palm Grove Beach Hotels against Hilton. What do you think the case is about? But the construction of another Hilton hotel. And this was in Pune in India. And the construction of that hotel took place before 2011. But that's not the dispute. The dispute was about management agreements around the hotel. And the management agreements were made sometime in 2013, with business starting in 2016. Then between 2016 to 2021, parties started quarreling about the management obligations of the respective parties. 3 tranches of arbitration seated in Singapore were conducted. Partial awards were rendered in 2023, and they went to the High Court. Thankfully, High Court gave decision in 2023, end of the year. The Court of Appeal gave its decision last year. 4 years from disputes arbitrated in 2021 to decision in 2025. Is that a delay, ladies and gentlemen? Then let me look at another case, July of 2025, in a huge case called Vietnam Oil. The Court of Appeal in Singapore partially set aside a Singapore arbitral award that had awarded substantial damages to a sanctioned Russian company. That award was set aside for breach of fair hearing, with the Court of Appeal remitting the award to the tribunal for further consideration. The High Court had initially found that there was a breach, but had refused to remit it. So it went up to the Court of Appeal, and the Court of Appeal sent it back. That was a case concerning a thermal power plant in Vietnam, contract made in 2013, commenced in 2015. And that was because of US sanctions. The parties ran into problems, and force majeure was contended between the parties. The tribunal's decision was in 2023. With it being set aside in July of 2025, it's now gone back to the tribunal for reconsideration. So, from dispute in 2019 to 2025, 6 years, is that a delay? Bearing in mind parties are now back in arbitration. And then I want to come back full circle again to Malaysia, in a case perhaps you all might know for its background. It's the ASEAN Bintulu fertilizer case. This delay rose slightly differently. After a 27-day hearing that took place between 2007 and 2009, the Arbitral Tribunal issued its award in December of 2014. The question then arose as to whether the 4-year delay in delivering the award was a breach of public policy justifying a setting aside. High Court answered, nah, it's not automatic, because the Arbitral Tribunal's ability to decide was not compromised by the delay. But the High Court judge took substantial time and deliberated on the matter of delay quite extensively, and so did the Court of Appeal. And one of the factors that was taken into account was the fact that there was no specific timeline adopted for the delivery of the decision, with a lot of no pushing by the parties to tell the Arbitral Tribunal, get on with it, can we have the award? And I think over the course of time, extensions were sought and they were all nicely granted. 2017, that decision was affirmed. So disputes went to arbitration in 2003, and finally in decision 10 years later. Is that delay? With courts now looking at emphasizing enhancing efficiency in terms of time as well as competency, disposal, I think, Tan Sri David, our time was 9 months. It was doable, I think, to a large extent, because parties helped themselves by, I can't get into this treadmill, I'm getting off. So a lot of matters actually got resolved. It was the last 15% that needed that rigor and that push by the courts. So, with the courts in 2009 and 2010 giving that push on efficiency and shortening time, it didn't look like ADR was going to be in a good place for a choice in expediting your dispute resolution. So where are we? When is delay a delay? It's so context-driven, isn't it, ladies and gentlemen? So, what was the landscape for PAM? And I move to my second issue. And prior to last year, I understand PAM's arbitration faced many institutional and operational restraints that contributed to delay, to your costs, concerns, and generally created an inertia and a lack of interest in wanting to use your very own rules. Amongst the complaints I understand was the fact that you didn't have somebody like Daniel sitting there encouraging everybody, with Anthony pushing him right at the back to make sure everybody arbitrate. There was just basically no proper management of your arbitrations. Just no officer, no personnel, and supposedly not somebody with legal expertise, or at the very least, the industry know-how to support and to administer the arbitration. And that's actually a very, very important element and reason why a lot of people choose administration of arbitration. They want somebody to administer and manage that arbitration. Why do you think Tan Sri David is at PCAM, and why am I at the AIAC? Sometimes the fact that the fees are floating around out there and generally found to be much, much higher than those imposed by other arbitral institutions, why were they so prohibitive as to get parties or prospective parties from rethinking and taking their business elsewhere? And whatever skeletal crew that was here at PAM, apparently, and these are not my words, these were notes from Daniel, there was a slow response time in the administrative correspondence, and this is so important. I just got back from the DIFC, Dubai International Financial Centre courts, and the key word there is expeditious, and you will find that also in the AIAC rules. It's not only just a matter of competency, but it needs to be expeditiously. It doesn't matter sometimes the costs but the time matters most. And when it comes to time, apparently the PAM arbitrations just got lost past the horizons and the time frames that I had given you in those several examples, such that people got lost in time. And another reason for the lack of popularity of PAM being your first and last stop in arbitration was supposedly this very small and relatively undiversified list of arbitrators. You had 13 for a long, long time, 12 architects and 1 QS. Nothing to be ashamed about, everything to be proud about. But it didn't help, from what I understand, because of the problems that we will know, that at the end of the day, disputes between parties have become quite a different creature. So what did PAM then do in order to address these concerns and these problems, recognizing that it was not giving itself a good name? This state certainly could not be tolerated. And I'm very, very proud to say, and I'm full of appreciation, that PAM took steps to address, to reform, and to reshape. Institutional reforms targeted at improving process and procedure were immediately put in place. You heard the President make the announcement of how your new rules are going to come into operation sometime this year. He's got 10 months to make sure that comes to fruition. And it's very important that these rules provide for default provisions, or in case parties can't come to an agreement, what to do then, what to do next, and to do so efficiently, expeditiously. I understand a dedicated case counsel in February of 2025 was appointed to administer and oversee arbitration and ADR proceedings. And what's another important step or measure that was taken was to revise your arbitration rules. And those 2 key points were highlighted by your President a while ago, and that is the matter of lump sum arbitrations, or 3 key points: expedited procedure for disputes which are less than 1 million, and to allow your President to determine arbitrators' fees by reference to fee schedules implemented by other arbitral institutions, particularly where parties are unable to agree. This is extremely, extremely important because the PAM Institute is part of the larger network of institutions which are rendering similar services, and you need to know what else everyone else is doing. You have also taken measures to improve communication channels through an official ADR mobile number, and if you are appointed as an arbitrator, you will immediately get into this chat group with WhatsApp facilities provided. And I understand a turnaround time for ADR correspondence is being in place. And of course, one of the reasons why I'm speaking to you this morning is your expansion of the PAM list of arbitrators from 13 to 24, and I believe the number is still on an increase, coming from other areas of expertise to complement what PAM already has. At the AIC, we realize that communication, case counsel are the frontliners, the ambassadors of the best services that any center can offer. And there is a rule of a 24-hour turnaround time. And I'm always on the lookout to hear, to be aware if we have fallen short. We have not responded within 24 hours, and we continue to improve. So that communication is extremely important, and communication, prompt communication, is another key to why an institution would be preferred. Now, these standards and to address delay and to improve efficiency are initiatives of PAM which must be lauded. It's a recognition that with the sophistication and complexification of disputes, methods and approach that are in place for a long, long time need to change and they need to adapt. The construction industry, I'm sure you're very, very well aware and proud of the fact that it is the backbone to any thriving economy, and it benefits all of us, and it certainly benefits with a mix of legal, technical, commercial expertise. So it will be very interesting, and frequently you will hear of arbitral tribunals with 3 different disciplines and being able to bring complete resolution to a dispute. Arbitrator appointments are now increasingly guided by dispute characteristics rather than by professional designations alone. So it's important that expertise is encouraged and it's promoted. Do not fear that stranger. We don't fear you. I certainly have had the whole host of expertise go through the corridors of the courts at the Attorney General's chambers and certainly at the AIC, and I have benefited from all the pieces of knowledge that I have gained through that mixture or that cocktail of expertise. Today's disputes, I don't think it's really any different from before, but it's a wake-up call to the recognition of how complex these disputes have been. I don't think it helps to continue complaining about how the lawyers have made it worse by legalizing a simple technical dispute because your client wants another voice. Your client wants another choice of whether my argument could be heard by somebody else. So after the arbitral process, remember in a project, you have a dispute and the project may be ongoing, it may be at final claims, it may be in process with other projects that are being conducted or handled by your client. It's all in a chain. And your client wants to know if that answer that was given by the arbitrator may be wrong, and therefore it will almost invariably approach the courts. And the courts have yet another gravy boat of process, and that will take time. And the lawyers, being lawyers, are only there to do their job, to offer you the best legal argument. And sometimes they are accepted by the courts and they become legal precedents. Most of the time, fortunately, they are not. But it is the attempt and the time taken through that whole process that add to the delay. But in those disputes, you will find, with so much expertise involved, these disputes, which are technical to start with, have become so complex because suddenly jurisdiction, the project's here in my backyard, but now jurisdiction becomes an issue. Why? Because the financiers may be somewhere else. The true party is actually a subsidiary of yet another company that is offshore. It may interface, your dispute may interface with other disciplines, say, for example, insolvency, intended or unintended. What happens then? Is the project stalled? Is the dispute stalled? What about parallel proceedings? That client may be sued by somebody at the same time. When all at the end of the day, it's just a simple contractual interpretation or procedural challenge that you have. But your technical, intensive, and extensive disputes have really, ladies and gentlemen, become very, very common. And therefore, it is no longer just your space. And at this point, let me touch on the use of experts, of one expertise or another. They have been engaged for arbitration. There is now, in fact, a growing disgruntled with such proliferation, with many now questioning if there is indeed a need to call these experts to start with, who in turn do not only agree among themselves, but they definitely add time and cost to your whole project. You therefore need a good arbitrator who will understand all these concerns and who can at least have these 5 attributes. First, they must have sound judgment and independence. They must be effective in managing that dispute and to be able to administer procedural discipline. They must have the ability to control costs and timelines. They definitely must be familiar with industry practice, and certainly, finally, but very important, they must apply your institutional rules and guidance. I've got my last 2.5 minutes, and this is where I want to offer the forward considerations. I understand, PAM, you're looking to consolidate on your reforms rather than to do an structural overhaul. I understand you are going to continue being committed to the list of arbitrators to maintain and evolve what is called a good and respectable balance between technical, legal, and commercial expertise. A mentoring and guidance program for newer arbitrators is underfoot, and I believe this is quite important to raise overall standards and promote greater efficiency, especially in the understanding of your new rules. All this, of course, is to make your PAM arbitrations more cost-effective, efficient, and making yourself a more credible institution when it comes to construction arbitrations. At the AIC, we launched our suite of rules this year. That's also very important. It's our key. We've added many features, and the January response from the users has been encouraging, and I was telling CIPAA, in January alone, we saw more than 10 new cases being administered under the new rules. The old rules have continued. We've got quite a few of the others, but it's the reception to the new rules that is extremely encouraging with our fast-track procedure and emergency arbitrators on the take. The fast-track procedure requires disposal of the arbitrations in 6 months. The appointment of the emergency arbitrators require a decision by me in 24 hours, and the decision on whether or not to grant the interim reliefs, they have to be made in 14 days. So all these are features perhaps PAM may like to take into consideration when you're appointing your arbitrators, the ability to deal with the demand. It's no longer about cost alone, but about the time taken. Workshops and continuing updates like what you have today, they are extremely important, of course, but let me add something perhaps that you would like to think about, and that's having and being engaged in caucuses between arbitral institutions, both regional and international. There is a conversation going on out there. Don't stand alone. Be part of that community. There is so much cross-fertilization, whether in community, the expertise, or the venue of last resort. All courts are talking to each other. You'll be surprised how much conversation is going on out there. Be a part of it. If you do not want to speak, eavesdrop. And it makes sense, certainly, ladies and gentlemen, to collaborate for greater efficiency and expediency. But there are 2 things you don't have, which we've made, and I'm very proud to have made sure that that was implemented, and it's part of our rules. Diversity. In appointing our arbitrators, we made it a positive commitment to make sure that there's diversity, and I do not mean gender, I mean in many other respects. Diversity is an important strength that you must take into consideration. And a small note, perhaps you'd like to consider having an online calculator so that your potential clients may know exactly what they're in for. So with that, ladies and gentlemen, I hope that I have delivered some thoughts on justice without delay, and I know for sure that PAM is raising standards. Thank you.
Thank you, Dr. Mary, for the insightful keynote, the suggestions, which I'll take to heart, and for setting the framework for today's discussions. We now move on to session 1, which addresses efficiency from the perspective of case management. Our next speaker is Tan Sri Datuk Sri Panglima David Wong Dakwa. Tan Sri David, please.
This is which. Good morning, ladies and gentlemen. Sorry about that. I'll just use this. I'll start again. My iPad is playing up on me. Good morning, ladies and gentlemen. Firstly, I thank PAM for inviting me to share my experience on this topic of case management for expediency, tools to keep arbitration on track. It is indeed a great honor for me to be here today, even though great weather for golf. Yesterday was better weather, there was no sun. Anyway, this topic is important because how arbitrators conduct their arbitrations gives credibility to the arbitration ecosystem, and in turn sustains our existence as a viable alternative dispute resolution ecosystem. So today, I hope to share not theory, but practical reflections drawn from my own journey in both the judiciary and arbitration. This morning, I will touch on three broad areas. The first is the foundation expediency, the proactive tribunal. The second area is the digital arsenal, and the third area, the human element. We have all heard many times, well, I have anyway, that arbitration is supposed to be faster and cheaper. But has that been achieved? I must confess, from my experience over the last 5 years, the answer is not always. The only arbitration I handle that I think fits the faster and cheaper description was the one I did prior to my elevation to the bench in 2003 and 2004. It was a multi-million ringgit construction dispute, and we were able to complete it in 1.5 years. And at that time, to get your case through the judicial system takes more than 5 years. My fees then were only 25,000. Now, even taking inflation into account, that amount was relatively low compared to today's arbitrators' fees. But again, somebody told me that's how much you're worth in those days. Nowadays, legal practitioners sort of tell me that arbitration is no longer cheap, and which is why they tell me they don't want to put the arbitration clause in the contract. Because the upfront fee that they have to pay, we all know, includes the institutional fees, the arbitrator's fees, which is substantially higher if you go to court, which is only your filing fees. So that is an impediment. And I'm informed JKR Sarawak does not have the arbitration clause in the contract anymore, right? So these are the things that is facing the arbitration ecosystem. Of course, when we say it is faster and cheaper, we are of course comparing ourselves to the judicial system. Now, as our competitor, I think I should say a few words about the judiciary. The judiciary today is not the one when I started practicing back in the early 1980s. When I had one case that did not come to trial until after 10 years. And by that time, my material witnesses has passed on. So what happened? The case was just disappear. I mean, I had to withdraw my case and that was it. Of course, the judiciary today is completely a different animal, so to speak. It sees itself as a service provider with accountability. What is that accountability? That is, the public expects the judiciary to dispense justice within a reasonable time frame. Now, when I was at the High Court in Sabah and Sarawak, we were given, like Mary says, a 9-month time frame to complete a case. Completion means that I had to deliver a full grounds of my judgment. And at that time, I was not only dealing with one case at a particular time. I had to deal with divorce cases and criminal cases. So that's crazy, isn't it? I mean, you don't expect the judge to finish a case in 9 months. So at that time, when a friend asked me, how's life on the bench? And I said, what? I don't have a life. So, I mean, and that was a reality. Weekends, and Mary would know that we had to work our butts off. And those who know golf, before I joined the judiciary, my handicap was 6. But as I continued to stay in the judiciary, it blew up to about 16 to 20. So, you know, but that said, I enjoyed my time at the judiciary. But, of course, now, my understanding is the judiciary, the judges face the same sort of time frame. They have to dispose of the case. But of course, I hear that the caseloads have increased and there are some backlogs now. And I think that is the window that the arbitration ecosystem should try to resolve. So this is a challenge that we are facing, and many litigants today still see the courts as the appropriate forum to settle disputes. Now, before I discuss how we should address that challenge, I think we should remind ourselves that we have a key advantage over the courts. Parties can choose their own judge, their own arbitrator, unlike in court. I mean, some say going to court is like a lottery. You don't know who the judge is, right? But in arbitration, you're able to look over the list of arbitrators on AIC's panel list, PAM list, BICAM list, and then both parties can decide, oh, this is the person that I want to resolve my dispute. That is very important. That is very important. This freedom of choice, we should not, belittle it. So, and that person is someone you would choose to have experts knowledge on the dispute that you're dealing with. It's very important. And I can tell you my experience. When I was appointed at JC, there was a big construction dispute coming before me. Rightly or wrongly, I told the parties, hey, I don't know anything about this, right? It could be a flip of a coin. Maybe I shouldn't have said that. I mean, as a judge, I shouldn't have said it. But in the end, what did I do? I said, there's a mediator out there, right? At that time, Habans was roaming around KK as a mediator. So I said, why don't you go and see Habans? And which they did. And within 2 months, they came back with a resolution, right? So, I mean, you're in the ADR ecosystem, you're able to pick somebody who's expert in that field to resolve. And I'm sure when that person resolved the dispute for you, the parties will be much happier, right? So, again, the other thing is the arbitrator's decision is final and binding. There's only one level of resolution. In the courts, the decision of the High Court judge is subject to appeal to the Court of Appeal, and then it may be to the Federal Court. That process is much longer than the arbitration. Of course, nowadays everybody takes the arbitrator's award to the court and all that. But I think in the majority of the case is thrown out by the courts because courts are very, I mean, as far as I know, the Malaysian courts are still very friendly to arbitration. And I think, if I may be wrong, more than 90% of those cases have been thrown out by court, and some of them don't even go to court, right? So that is an advantage that we have, right? Then, now to ensure that the two advantages are not lost, and to address the challenge that I mentioned earlier, we must have quality arbitrators who can offer a faster, more effective alternative to litigation. Sometimes we can't deny that the process becomes bogged down, protracted, and increasingly expensive. My experience it gets bogged down because in Malaysia, my experience anyway, the lawyers who are handling arbitration are the same lawyers are practicing in courts. Their calendar is full all the time, right? And if they apply to the court for adjournment to do an arbitration, the court says no. This is more urgent. So there lies the dilemma. There lies the dilemma. So okay, that's right. So I will now, with that, I will now go to my tools that we can use to make sure that our arbitrations be kept on track to keep the arbitration on an efficient, effective, and cost-sensitive track. Of course, the first thing is the tools I'm showing you is to ensure that we have a proactive tribunal, right? Now, I think we can say that to me, efficiency begins before even dispute ever arises. It's a drafting stage. It's important that we have a good arbitration clause. Beyond I've dealt with one case where the arbitration is so badly drafted, it's just challenging on jurisdiction already, right? That takes time, even though the arbitrator has the power to determine on his or her jurisdiction. That takes time. So the two clauses up there are not ideal for use. It should not be used. Now, this one is pretty clear. This is the similar to clause. This is, of course, is the Bickham clause. I think the AIC has a similar clause, and it says any disputes arising out or in connection with the contract, including any questions regarding to existence, validity, or termination, shall be referred to and finally resolved by arbitration administered by the arbitral institution in accordance with the procedure rules for the time being enforced, which rules are deemed to be incorporated by reference to this clause. Then you also said what the seat of arbitration shall be. The arbitral tribunal shall consist of how many arbitrators, and the language of the arbitration shall be. So this is the model clause which Bickham has, and we think that it's quite clear there. So it's important. I mean, if any lawyers out there or you are involved in drawing up contracts, make sure that sort of clause is in there. And of course, now it's quite popular clause is the met up clause. Again, my experience here, if you not have this drafted properly, again, there's jurisdiction question. I had one where also said, look, you never went to mediation. There was no mediator appointed, so there was no full mediation. What happened there was the parties were not keen to go on mediation. So you have to, in your clause, to make sure that certain conditions have to be filled to make it that you have gone through mediation. So again, drafting of the clauses is very important. Now, before I leave this topic, I would like to refer to this case of Sabelliam's enterprise case. It's important because in Malaysia, we have two high courts. One high court of Sabah and Sarawak and one high court of Malaya. So this case actually concerns the PAM contract 206 of a development project in Sabah. The arbitrations was held in KLRCA, now AIC, and finally the arbitrator handed down the award. Now after the award was handed down, the winning party filed an application to enforce the award at the High Court in Malaya, in Kuala Lumpur. But the losing party filed an application to set aside the award in the High Court of Sabah and Sarawak in Kota Kinabalu. So you have two proceedings going there. Then this winning party went to strike out the application to set aside the award in Kota Kinabalu. The application to set aside was set aside by the High Court, but it went to the Court of Appeal. The Court of Appeal said, "Oh no, you have two High Courts here, the the High Court of Malaya has jurisdiction, the High Court of Sabah and Sarawak also have jurisdiction. And because they filed it first in Kota Kinabalu, it's okay. And then it went to the federal court, and then the federal court then decided what the seat of arbitration would determine which court has a supervisory power. So in this case, the seat of arbitration was Kuala Lumpur. So in the end, the High Court of Malaya is the supervisory court. Of course, I don't know about Mary. Mary knows about my feeling about this case because in that it actually ignores Section 23 of the Court of Judicature Act, which says, and then not many people know that the Court of Judicature Act is the second most powerful act. Second act, well, I mean, after the Constitution of Malaysia. So in Section 23 of the Court of Judicature Act, it says that where the cause of action arises, right? The cause of action arises in this case, was in KK. So, but anyway, but that's the law of the land. So when you're drafting this course, make sure if you want your supervisory court to be in High Court of Sabah and Sarawak, make sure where your seat of arbitration is stated. It's Kota Kinabalu or Kuching or whatever. Okay. Now, with that, I move to the next tool, which I want to take you through, is the Case Management Conference. Now, if you look at the PAM Arbitration Rules 2025, you look at it, it gives the arbitrator wide powers. It gives them, it's like the courts. The only difference, of course, the courts, the judge has more power than, say, an arbitrator. Is that it actually tells the arbitrator shall convene such meeting for the purpose of giving directions for the conduct of the arbitration. The arbitrator may direct the parties from time to time such other meetings or hearing as the arbiter thinks for the purpose of the arbitration. So if the arbitrator is proactive, there's a lot of things they can do. But of course, experience tells me that sometimes the parties are not cooperating, right? That's where the dilemma is. But from my perspective, what I do is, before I even reschedule my first preliminary meeting, I send out things like this. Pre-circulated agenda. So I send out my agenda out to the parties before I even call the first preliminary meeting. They will have a meeting among themselves. Apart from this, I also send them their procedural timetable, right? And the last and most important item is the arbitrator's fees, right? And it's like that. Okay, let's just go back here. This is important because once the meeting is held, all this blank has been filled in and sent to me, sent to the panel, and then it's just ask them to confirm this at the first preliminary meeting. So then, same with this, the parties would have got together and determined when they can have the trial and all that. So this is party driven by the arbitrator. And the last one is the fees. Of course, usually we just follow the fees by AIC or BICAM. But there's one item there which is of interest, is the, where is it? The daily fees. The daily fees, where the panels that I've been involved with, we usually charge $8,000 a day. Now, there's reason for doing that, because if you don't have a daily fees, the parties will continue to drag on. They will take, there's no incentive for them to finish the case, right? But sometimes the parties will not agree to it. So what do? I will say, how many days will you take? I will take 10 days. Okay? After 10 days, there will be a daily fees of $8,000. They would agree to it, right? So this is an item we can use to make sure that the parties keep to the timetable. The other item of interest is if there's a cancellation fees of the hearing, you know, if you're 21 days before there's no charges, if you cancel between 14 to 20, there's 50%, and if it's 13 days, it's 70%. Recently, they canceled it 1 day before. So we're going to charge 70%, 75%. So, right, you know. So you may like to use this sort of, you know, form to send out to the parties before you even start the schedule. And I can tell you with this, your first preliminary meeting would not even take more than half an hour. For 15 minutes, you finish. All right? Now, the next tools which I'd like to bring your attention is called the terms of reference. Now, I'm grateful for Pam to ask me to give this talk because I had to do a bit of research here. So this is the first time I come across this document called a term of reference, because, I mean, those involved in ICC, they would know. But I'm a local boy, so I'm going to do Malaysia. So, so this document is mandatory as if you're doing ICC arbitration. And it's nothing extraordinary. You would have done it probably informally. But if you actually have this in your rules, actually it's very good. And I'll tell you what, I tried to do something like that in one arbitration and the result. But let me take you through this. Right. This term of reference would be a result from meetings with the parties. Right? They would draft jointly their claims, their respective claims that they have, the relief they're asking for, details of the defense and the respondents, of the respondent, and jointly framing the issues to be determined. And then, of course, determine the law and seat of arbitration. Now, what's interesting, they have to finish this document within 30 days of the close of pleadings. So they're really pushing it. I mean, I don't do any ICC, but my experience, the people who are doing the ICC one, they don't feel, how do I put it? They don't feel any reluctance from the council, because I think when you're dealing with international arbitration, the money is so big, and they're employing cases and all that, dealing with it, and those arbitrators tells me that, you know, they don't have this reluctance to cooperate with the tribunal, because I suppose the money is big. So they must have this done 30 days before. 30 days after the close of pleading. So why is this document important? To me, it provides a roadmap for you before you even start hearing, right? And it's important. It's important. I think we try to do it in courts. Sometimes we are successful, sometimes we are not, because parties or lawyers just want to keep their card to the chase, to the chest. And they want, I don't want to tell you everything now, you know, I'll tell you later. That's the mindset. But I think we as arbitrators have to change that mindset, right? So now, my experience is that I tried to do this, right? I never knew about TOR. So before the arbitrations started, I said, oh, okay. These are the 10 issues which I think is relevant to this. I didn't hear anything back. So after 2 or 3 weeks, it came back. Both sides I gave them 10. One gave me 20, the other gave me 25. So I had 2 co-arbitrators. Hey, what are we going to do? And I said, what can we do? Because they don't trust your framing of the issue, right? And of course, in arbitration, it's party-driven. And I mean, party-driven in the sense that as arbitrators, we are always mindful of the fact that you are determining something that is not in a term of reference, and it'll be set aside, right? So that is one. So now, if on hindsight, if the arbitrator sits down with the parties, say, hey, the rules requires us to have this TOR, right? I'm bound by it, you are bound by it. Let's sit down and put all this down. Now, I can tell you as a judge or as arbitrator, if you give that to me, I tell you the arbitration or the trial will go smoothly. Right? And I say that, and Mary is not in the head. You know, as a judge, you sit there. I mean, all I'm interested is in this issue. You don't bring me witnesses that has nothing to do with this issue. So, I don't know, Mary, I mean, I don't know where AIC have this in the terms. I'm sure I'm going back to Bickham and say, hey, let's have a look at our rules again. I mean, after having your 2026, Bickham's also have to catch up. So to me, I mean, again, I'm grateful to PAM. I had to do some research, and this is the one thing I found out, and I enjoyed. So this is the thing I was just talking about. We have to, the real issues in dispute. Many a times, I'm sure many times in court, I said, parties, what actually do you want? What actually do you want? They are so reluctant to tell you, right? So, and the same in arbitration. So once the issues are clearly set out, it's smooth sailing, I can tell you. So that again brings me to disclosure. Again, if you have your TOR, your issues all set out, what are the documents? What are the documents? Huh? I mean, when I had my first arbitration, I thought I should just follow the normal thing. Okay, send me all the hard copies. After 1 or 2 cases, my daughter's office was all full. So now, I said, I do not want any hard copies or soft copies, right? Now, did it affect the way I make decisions? Did it affect me knowing the case? No. Invariably, the documents that's submitted, I would say only 10 or 20% are relevant. That an arbitrator has to look at it, right? The other documents are peripheral, you know. And if we are able to get the parties to agree to the issues and all that, and say, look, I need disclosure only to these documents, that I can tell you, if you're arbitrators, that would be godsend. I know it's hard to attain. I've been trying for the last few years, but I can't say I'm successful. But having know the TOR now, maybe I'll take another tack. All right? Okay? So the next issue is managing witnesses. Again, I come back to TR. Everything is, I mean, all the arbitrator's job is to determine what's in dispute between the parties. And what in dispute in parties is in the issues being framed. That's all, right? The question is, why don't you like me? Why do I like you? Why did the thing go crack? Those are questions, those are issues. Once those issues are out, everything flows, right? Okay, so the second last, I come now to my second last topic, which is did you ask no? Again, this is more to the institution. We should have, I mean, Bickham have something like that. I mean, ICC has, they're using ICC Case Connect, Optus 2 and all that, which is actually what the courts of Sabah and Sarawak have. And in Bickham, that's what we have. Actually, what it does is, once you case is filed, we have a folder, so to speak. And that folder will contain everything, all the pleadings, all your application, your submission or whatever. Now, that portal is accessible to the parties and the arbitrator, right? So if you were to file something, the system would trigger a notice to the arbitrator or the other side that something has been filed, right? So it's not like I receive an email, I don't know, there's one arbitrator, so it's 50 email, you have to scroll through them, you can't even, sometimes you don't know which document you refer. So with this, with a system like that, everything is there, right? What we developed in Bickham is actually a reflection of what's been done in the courts of Sabah and Sarawak, which I had some hand in developing it. So we found it all very convenient to it. There's a triggering system, anything filed is there, So I think it's important that all institutions should have that. Of course, apart from those management, technology is there, transcribing everything like AIC's got, and most institutions would have that. All right. So to me, that portal is very important, and it helps everybody. It helps the parties, helps the arbitrators, and all that. Okay. Right. Of course, the last topic I'll talk about the human elements. Of course, strategy over technology. Of course, like Dr. Mary says, AI is with us. I think it's something that we cannot ignore. We must embrace, but we have to be careful with it. Now, everyone use ChatGPT in their work? Anyone put their hand ChatGPT? Oh, good. Right. I don't use ChatGPT, but I use Gemini. I use Copilot. Now, I don't think you should be fearful with. I was told a story. The lawyer the other day told me, he received a statement of claim, 50 pages, and the clients wants to see him next morning. I mean, it's humanly impossible to sort of scroll through 50 pages statement of claim. Oh, what did he do? He put it to Copilot. Summarize for me. What are the areas of law involved? That can be done in 3 or 4 seconds, right? And I confess, when submissions are given to me, I put it there, summarized for me, right? At least I got the salient point and what it's about, and then start reading. So these are the tools that we should use, in my point of view. It's not something that, we hear negative things about AI and all that, but we must embrace it from my point of view. But of course, we have not got the time, or I haven't, is put all my submission in there and please write me an award. But having said that, personally, I don't think that's far away. I know it's there, but no arbitrators using it yet. They have? Yeah. I tell you this story. A senior counsel got the other side's, wrote his submission for the Court of Appeal. He is to appear next week. So we put it to ChatGPT. Please tell me the questions which the Court of Appeal would ask. Came up with 6 questions. The Court of Appeal asked 2 questions. Exactly on point. Right? Those are tools that we need to know and we need to use. It makes us more efficient. Right? Right? Imagine I get a submission from counsel as my arbitrator work, or especially in interim measures application, which I had. They were trying filing interim. In that case, I tell you, I did use Copilot. Summarize for me, right? Because I had to make a decision, right? There was an interim measure asked, and that helped for me to get me what the idea is, and I start researching on that. So don't ignore AI, or and please use the paid version, right? I mean, it's not that expensive. It's not expensive. So, on that note, I just want to conclude by saying that we must develop a system, arbitration ecosystem, such that people would come to you, right? What do I mean by that? I'm not trying to sell myself, but I have one case which completely out of the blue, right? The parties were fighting in court. There's no arbitration clause. And I said, no, I don't want to go to court. If both parties agree to go appoint David Wong as the arbitrator. Now, in other words, in that case, the litigants and the lawyers are happy to take it out of the judicial system and let an arbitrator to deal with the thing. So we can and we need to develop a system where our arbitrators, people are comfortable with, right? And know that their case will be disposed of in a cost-effective way and with a sound award, which should not be set aside. So on that note, thank you very much, Daniel. Thank you.
Thank you, Tan Sri, for the insights and on discipline and technology-enabled management of proceedings. Our next speaker is Ms. CIPAA Selvaratnam. Ms. CIPAA, the floor is yours.
Good morning, ladies and gentlemen. My biggest nightmare when I come up to speak is whether I'm taller than the rostrum. So tick, fine, that's cleared. It's such a pleasure to be here. And I thank you, Pam, Daniel, Anthony, thank you all for inviting me to be part of this really esteemed group. Iconic speakers from the dispute landscape, a room full of peers, professionals. What a privilege it is to be here with all of you. And I truly applaud PAM for all the initiatives that you're making to refresh your look and feel. I remember PAM being one of the pioneers in the Malaysian arbitration space, and it's wonderful to see you reclaiming that position, and I wish you all the best. I am clearly an oddball here because I am not part of the construction industry. And the little bit that I dabble in, in construction, it tends to be maritime facility construction. And so I'm in awe, and I salute you at the way the arbitrators handle meticulously the disputes and the construction issues. I remember way back, many, many years ago, when I was dealing with architects and arbitrators and engineers to construct a little house, my little home. And I thought to myself, oh my, how much work. We lawyers have it really easy. So thank you again, architects, for doing such a great job. And thank you, Daniel, who I sadly miss working with now that we have both left the firm of Tommy Thomas, for actually finding me quite a simple topic to speak on. And so, what is it that I hope to cover in the time allocated to me? Well, it is basically speaking how awards that speak clearly. So drafting an award, which is close to my heart, quite simple, really, and making it brief but effectively. So, if I start from the top, really, the obligation of the arbitrator, the primary obligation is to issue an enforceable award. Not everybody wants it enforceable, certainly not a party who believes they're going to lose. They'll do everything they can to thwart that, but let's put them aside. And the fundamental obligation of an arbitrator is to issue an enforceable award. And therefore, that obligation actually frames the entire drafting of the award. And if I can also state another truism, it would be this. There's no single style to drafting an award, besides the fairly obvious things that you have to state the critical elements, the arbitration agreement, the date, the seat, sign it, perhaps the law as well that you've decided to apply has not been agreed. And the rest of it is really artistic license. But if I can set out right at the beginning, this is that I find it very useful when steering my artistic license to identify my goal. My goal in issuing this, drafting and issuing this award is really with a view to persuading the parties that no further review of this award is necessary. And you can only do that if you really make them feel heard and understood. And that's why matching your arbitrator to your dispute is so important, to feel understood. And therefore, you provide them with the reasons for choosing one argument more than the other. There's only the more correct position. There's never the absolute position or absolute truth in any dispute. And with that, it's hoped that there would be a minimal challenge, of course, taking aside the party who is inevitably going to challenge because of the desire for that priceless commodity to buy time. But let's put that party, that kind of an individual or entity aside, and just focus on what it is that would persuade a party not to review, and therefore, what is it that would render an award most likely to be enforceable. So we come to this really. The common challenges to an arbitration tend to be, or successful challenges to arbitration tend to be twofold in my mind. And the first is that it does not fall within the scope of the arbitration in the handling of the award itself, in the handling of the arbitration. So to use the phrase that is found in sections 37 of the Arbitration Act, 37(1)(a), 4 and 5, it would be that the award contains decisions on matters beyond the scope of submission, or award deals with a dispute not falling within the terms of the submission. So loosely speaking, the award strays outside the scope of the party's submission. That's the first common ground that succeeds, and something that we really have to pay attention to. And the second is to make the award such that it is fairly watertight, or it's foolproof from the perspective of natural justice, and that there has been no a failure of due process in making the award, in carrying on the arbitration itself. And that comes from, again, from the Arbitration Act itself, sections 37(1)(b) to and 37(2)(b). So putting this in the umbrella framework of the Arbitration Act, that's why the enforceability of the award is so important, because we can stray out of the scope, we can fall foul of our obligations of natural justice. Right, so what is it? If I take scope of arbitration first, is that there is actually a good practice, and Tan Sri has spoken about it, of having issues framed. For me, that puts us in a straitjacket. Once parties actually give us the issues, then you know that's where you're going to go. The temptation to stray out and deal with anything that seems interesting, that actually tickles our fancy because it's something we're very good at, is put aside. It's tempered, that temptation itself. So what I do in practice, and thank you, Tan Sri, for referring to the TOR, but we'll have a nice coffee session after this, and I have a chat on the TOR, in fact, about how it is maybe finding its way out, even in the ICC. And you can do it in so many other ways. And what I have always done is, at some point in my procedural timetable, I call for parties to give me their list of agreed issues, and if they can't agree, respective issues, for me as the arbitrator or my tribunal to settle it. And once it's settled, so it's party-driven again. So rather than giving the 10 and they come back with their 20, I say, you give me yours, and then I will put them together, and I say, is this the common position? And inevitably, that because then the arbitrator steps into that space, They tend to agree and then ask them to sign off on it, dated. That, for me, is critical to keeping me in the scope, reducing the chances of a challenge later about exceeding my scope. Now, the issues itself would have a precursor. It might have agreed facts. Yeah, and that, again, is party-driven. They could set out what it is that they agree or not disputed, and that's a second lot of documents that are very important in crafting and drafting the award. Now, this I don't know if it's very common, but it's something I learned when I was on the ICC court for 6 years, and is that when we draft our award, we actually footnote where it is we are getting our respective statements in the award. You know, we always say this is what has been said. We would state the issues, we'd state the party's position on each issue, and in doing so, it's quite important to footnote exactly where it comes from the pleadings, what page, if there's a common hearing bundle, what page, such and such, or the submissions, as the case may be. So again, think of how it reflects to a party thinking about even a challenge for out of scope. It's referring to the party's own resource, the party's own position, and it makes it very, very difficult to challenge an arbitrator's award that's so succinct, so accurate and precise in deriving its statements in its award. So footnotes are a very good thing to do. And what it does, this footnoting, very annoying, very time-consuming, very costly, and that's when tribunal secretaries become necessary as well. And I think we are in the midst of having a training for tribunal secretaries, so they provide a core group that can support the tribunals. And what does this do? This footnoting, this precision, even though it might be more costly in some ways, and the tribunal secretary reduces that cost, it is a discipline. It's a discipline to say whatever I state in my award, it comes from you, the parties. I'm not straying out of that. And it may seem also basic, but I can tell you this. There was only last year when a panel of very eminent judges, it's an international arbitration, panel of 3 Indian judges. The chair was the Chief Justice, former Chief Justice of India. The 2 co-arbitrators were Chief Justice in their 2 different states of India. They issued their award. It was parallel to 2 other arbitrations, and it got set aside. It got set aside by the Singapore Court of Appeal, well, High Court and then Court of Appeal. And why was it set aside? Because this arbitration award, and it had 451 paragraphs in it, 212 paragraphs had been cut and pasted from previous parallel arbitration awards. And what was wrong about that? I mean, cutting and pasting is off to begin with in such lock, stock, and barrel manner. It cut and pasted the wrong submissions from the other awards, which were not actually submitted in this award, in this arbitration. So if only they had footnoted, perhaps things may have been a little clearer at that point in time, the double checking. Even if the chair went awry, the co-arbitrator says, you're saying this, but your footnote doesn't match it. Where is this coming from? That's where the check and balance comes in, to have precision. And we are now, ladies and gentlemen, in this era where arbitration is almost mainstream dispute resolution mechanism. The stakes get higher, the expectations are very high, the rising bar is quite rightly rising, and we can meet it. It just means being more meticulous, more precise, getting the necessary tools and aids, and delivering what it is the consumers and the users want. Now, that was Singapore and the Indian tribunal, but back home, I also get comfort and support from this suggestion that we state where we get the source of our statements in our award from decisions of one very recent Court of Appeal decision. I call it the Toshiba elevator case, 2025. I think it also goes by the name of Eng Han. So you can see that for yourself. But it set aside a tribunal, industry tribunal award, because it raised two new matters in the cause of the award. And the guidance that that court gave, the Court of Appeal gave us, is to say that, look, while the tribunal need not state and set out all evidence adduced, thank goodness we can't, then the whole record will be reproduced, but there should be some detail of the issues and the evidence that was brought before the tribunal, and that makes it the decision of the court, the function of the court, much easier, more concise, easier to throw out unmeritorious setting aside. So take that on as something that is really good practice. Now, I'm speaking on scope right now, scope of submission. Scope is many layered. It can have a different level of complexity beyond just getting issues and footnoting and referencing. I will come to that after I've done with the natural justice. But before I leave the scope, I also want to say that in fact, the reasoning becomes very important. And I think your PAM rules provide for reasons to be given, and that's common. Unless parties request or agree otherwise, reasons ought to be given. And I think that's in your Rule 21.2. And as a lawyer, a practicing lawyer for 33 years before I became an independent arbitrator, I can safely say one of the single most important factor a party's advisor will look to when considering whether or not to challenge the award is, in fact, looking at the reasoning of the award. Is it logical? Is it clear? Is it consistent throughout? Is it coherent? And does it stray away from the issues and submissions? Because once you look at it that way, it's very clear, concise, logical, it flows, it's within the issues. How does one challenge it? What holes are you going to poke into that award? Which court is going to entertain that kind of challenge, knowing that our courts are supportive of what the tribunals do, and they defer to determinations on facts that a tribunal makes. So the reasoning is so important. Now, I point this out because it's easy to say, well, these are the issues, and these are the submissions, and then the tribunal goes on a frolic of its own in its actual reasoning, departing from having set out everything. So the reasoning matters. Now, the reasons, if I could say, should actually reference the documents, again by way of footnote, the testimony of witnesses. Now that's very crucial, I feel. Excerpts of testimonies of witnesses in the award, so not just footnote, but passages of that speak volumes. It actually it alerts the court to why we are making that finding. Hey, how can I ignore this whole chunk of evidence given in the party's own witnesses' words when I make my finding? So what it does is it actually does two things. It alerts to the court who is looking at the review that these are findings of fact. Do not interfere, because only the tribunal could actually appreciate the value of that evidence. And two, it's clearly within the scope. When this evidence was being led, when this evidence was coming in cross-examination, there was no objection. Clearly within the scope. And of course, it then is justified for the tribunal to rely on that in arriving at the reasoning and the decision that it did. So that would be what I'd say very quickly in terms of the scope for now. I'll come back to it. But another matter that is, oops, did I go the wrong way? Helps to hold it the right way up, is due process. The power of due process and natural justice. Now, it's critical to feeling heard, the due process and natural justice. And remember, my goal is to make the parties feel heard so that they are persuaded that they've had their day, as we often hear, had their day in court, their day in arbitration, they feel heard, they feel satisfied. And technically, we're also protected from the legal perspective of having done due process and natural justice in giving them an opportunity to be heard. So what is this power of due process? It is the power of the satisfaction of the party. When it's the party's satisfaction that I've been heard, that's the power of due process. You will be left alone. Your award would be received with both hands, winning or losing party. And so I often pay a lot of attention to this. And it is actually the most fundamental feature of any administration of justice system. And arbitration is an administration of justice. It's private, but it's still a paramount justice system, almost running in parallel with the state courts. And of course, your rules, I think it's Rule 6, 1, talks in terms of PAM rules, fairly and impartially, and affording reasonable opportunity of putting their case and meeting the other party's case. And I love that words that they use, PAM has chosen. It has used reasonable opportunity, not complete or total opportunity, just reasonable opportunity. And that is the minimum we can do. It's a cornerstone, as I said, of a justice system. Now, it's now, I come to this because it's integral to the due process for arbitrators to curb the innate temptation to find the right answer. And you would think, isn't that my job, to find the right answer? Isn't that what parties are paying me for, appointing me for, to find the right answer? And there's an overwhelming impulse for us, because we are professionally trained in whatever discipline that we are trained in. We've spent years doing it, and there is a sense of right answer. In this situation, there is a right answer. And in fact, that kind of strong sense is very important. That characteristic makes us good arbitrators. That means we are decisive. We can decide. We know immediately we can decide. But the point here is to not get carried away with the right answer, and to just restrain it a little bit, and to be decisive, but to understand that it is the party's process, finally. It is the party's process, and it is therefore important to understand that the process may be as, or in fact more important than the right answer. If the parties choose not to canvass a point, it is their liberty to do so. It's their right to do so. We'll come to exceptions, but certainly that's where party autonomy comes in. And we also have to pause to remember that arbitrators don't set precedent. Yeah? There's no right answer in the interest of a public or greater good. There's no such thing. We're just deciding it between the parties to this dispute to find the more correct answer as between the parties based on what they have chosen to put before the arbitrators. Okay, so this is the politically correct answer that I've just given you. And that indeed must be the way we approach it, because it's so integral. I'll tell you what I struggled with and how I now am able to veer and toe the line of the politically correct way. It still is difficult, and we will see how far we get with it today. If Keng Ho is going to also challenge us, I think, on some of that perhaps in the panel session. I struggled with it especially when I was acting both as counsel and arbitrator. So as counsel, the obvious arguments would jump straight at me, and this should have been said, and that should have been done, and why are they not saying this? And they haven't said it, and I have to respect that. That's one thing. Arbitrator not trying to be too clever. Just do our role as being independent, non-biased, seeing what's before us and deciding what's before us. But what is more difficult, and that you can do after a while, but what is more difficult is when there's inequality in arms, when one party has strong representation, is throwing, the kitchen sink and everything, every document, every argument from the arsenal brought out, and the other party has got one counsel, obviously preferred counsel by the party, maybe it's a cost issue, and struggling. And what does the arbitrator, who can see things but cannot step into the fray, do? that is not just in domestic situation, I've seen that domestic, it's worse in the international scenario when you have the QCs leading one team and you have a developing country party on the other side who have issues with language, issues with even understanding the whole process of arbitration. So it's a very, very real struggle. So again, the temptation has to be resisted to improve a party's case, because that would be twofold. That would be exceeding the scope. This is where I come to the overlap. That's not what they said. I don't know why this clever arbitrator is trying to improve it for them. Yeah? And two, it's also ties into due process and natural justice. Right? So, that's the gray area I wanted to raise, and what do I suggest doing at this stage? I give you a tactic, but it must remain here. And it is this. I see something, it's so obvious. It can be so obvious as a party, arguing a force majeure, and because of COVID, and not citing the COVID Act and the exclusions that come there. And I'm like, oh my God, it would be a derogation of my duty. Because finally it's the party, and if council is not stepping up to the game, it's the party who's going to suffer the adverse effects. And yet I must maintain parity between them. I cannot improve it. And I'll say, this is force majeure. So I'm very confused, and I'm very perplexed. Does the COVID Act apply in this situation? And then everybody's eyes will sort of light up and look at each other and said, then I'll say, can you both take additional time to think whether it would apply? And then if you need time to address me on that, both parties approach me for extra days, what number of days you want. The point is, when it needs to be said, and it is within the scope, so I have to clear that first. Is it within the scope? Of course. It is a force majeure situation. It is force majeure arising out of COVID. Of course, it has to be within the scope that I should consider the COVID Act. Even if I'm going to dismiss it, I should consider it. Otherwise, I'm letting the parties down, the dispute down. And so it's within the scope. Then my next thing is to invite both parties to submit on it. Then due process is achieved. Both are given the equal opportunity to address that particular issue that's come to me, and then I move on as part of the thing. You might extend the issue to one more issue if the parties so, is this suitable for me to add as the issue? If parties agree, it's enlarged. Otherwise, at some point, I would narrate that as a procedural history and how I call for this extra submission. Parties gave the submission, and I, so on and so forth, decide to go one way or other. And it's the process that matters. And that's the thing I want to do. I wanted to highlight. It's the scope first and the process of how we achieve it. Now, what is also lovely to see in the Toshiba case is the Court of Appeal there bringing in what was considered by the Singapore Court of Appeal in Glaziers and Engineering. And how they did it was reproduce the passages, and what the courts have said there is how they deal with surprising outcomes. So when this, for instance, the COVID Act thing, if the way I may have or may not have decided on it could be a surprising outcome. So the courts took this into account, how sometimes there could be a mismatch between the submission itself and the outcome of the award. And they categorized the surprising outcome. And this is what they say. There are several distinct types of situations that give rise to surprising outcome. Some could amount to a breach of natural justice. The pivotal question is whether the parties have been deprived of an opportunity to be heard. And they set up 3 different categories. I'll quickly do this, if I may. Oh, I only have 2 minutes. Okay, fine. They said this. Okay, so it's a determination is quite different from either party's submissions. Example, party said Singapore law could apply. The other party said it should be Chinese law that applies, and the tribunal decides it's US law. And so the court said, but you did not give the parties an opportunity to submit on the applicability of US law. Strike out. another situation where the surprising outcome is parties argued that a port was unsafe because there was not enough water for the vessel to go into dock. And the tribunal said the port was unsafe because there was not around enough turning space for the vessel. And the court said, out, breach of natural justice. There's no even, you didn't even invite evidence of there being inadequate turning space, so for evidential reasons. And they said this, it's the function of evidence. You may know, and that's another area, very quickly, if I may come to in a minute, the evidence of the evidence must be before the tribunal, before the expertise of the tribunal can even be put to use. So that's struck out. But what is it that is not in breach? And this is what we all like to know. And it's this, the surprising outcome is when the parties omitted to address, I'm going to almost read this so that I don't go on a frolic of my own, parties omitted to address a particular issue, even though they could have reasonably foreseen that issue would have formed part of the decision. So it becomes a reasonably foreseeability that a tribunal would decide it, not decide on what A has said or B has said, but a permutation of that somewhere in between. And sometimes parties should have been alerted, but chose not to do that. And having been counsel, we know sometimes we don't do that. We don't want to give ideas to the other side, or we don't want to give ideas to the tribunal. But if you don't, then you can't complain if the tribunal too saw that idea. So it's the reasonable foreseeability when a permutation, it comes out of the arguments itself, but the variation in how they determine that, that's okay. That's okay. So use that when you have to. But when in doubt, call for the evidence. I'll leave you with maybe one or two more matters very, very quickly, and it's this. Okay, I don't know whether I should flip to the next slide. Okay, yes. It's this. In the Pancharan primer case, this is about tribunals using their own expert experience, and all of you would have that right to do so, and that right is given to us, given to you, given to lawyers who specialize in a particular field, to use their expertise. It's Section 21(3)(b) of the Arbitration Act. And in Pancharan Primer, the federal court said, look, they accepted that using your own expertise was foreseeable in light of Section 21(3). But you have to say there must be enough evidence to allow you to make that finding, and then you can go ahead because it's reasonably foreseeable and therefore not truly surprising to that extent. Now, Toshiba case, the tribunal there exceeded the scope in relying on two matters as an engineer as well. The Pancharan was also an engineer, and the court said, look, but that engineer in Toshiba did not say that he or she was using their own expertise, and there wasn't enough evidential foundation to formulate that, and therefore it was set aside. CIPAA, this is the last one I will say, the CIPAA case, MMHE, there the award was set aside because the expert evidence was not followed, both parties. But the tribunal, that's okay. If you come back to your own finding as to somewhere in between, that's okay. But you have to say why and how you arrived at that in-between position. Their failure to do so meant that, it was set aside. So having said all that, procedural history, just very quickly, you know what it does. It shows that the whole process adhered by natural justice due process. That's why it's important. The test given by parties, deal with it. Say why you accept, why you don't accept, distinguish it if necessary. And finally, in all the details that we have, a lot of the thinking, especially for the construction one, so much nitty-gritty, stop, pause, and finally just look at when you summarize the issues, and it's always good practice to summarize the list of issues, the issues you called ahead, put them down right at the end as a summary, and then your findings on each of them to make sure it's coherent, consistent, you've dealt with every issue. Check your dispositive, the final orders that you make. It must match the pleading, the relief sought. If not, out immediately. Yes, very simple, very important. What do? I mark out the witness statements, the testimony, the documents, take out what I would put in or need to footnote, isolate contractual provisions that will focus where my decision is going, identify the compelling passages from legal authorities, and then make sure the structure flows. Issue 1 may not be the first issue I want to deal with, because issue 5 may set the foundation to all of the other issues. So structure, so that it flows, it's coherent, it's consistent, it's logical. Use headings and subheadings, and conclude each heading of issue with a finding. And then you're neat, you're compartmentalized, you're logical. Who can challenge you then? Well, the party who's always going to challenge you anyway. Barring that, I think it makes for our discharge of obligation complete. Thank you very much.
Ladies and gentlemen, our final speaker is Architect Tiong Kien Boon. Yes, Architect Tiong, the floor is yours.
Test 1, 2, 3. CIPAA says she's the odd one out. I think I'm really the odd one out. Thank you very much, Daniel and PAM Council, for asking me to speak. I think I was chosen because I'm the last of the fossils. The rest of them that came before me in PAM as arbitrators have all passed on to the other side. The last one I think was W.Y. Chin. Before that was my mentor, Tan Eng Kiong. Okay, the first time I actually heard the term arbitrate or arbitrator was in 1976. The School of Architecture in Canterbury has a practice of having a monthly open lecture that is open to the whole school. And for some reason, they have chosen this strange person who is called an arbitrator, and he's going to talk to us about arbitration. I still remember an introductory skit performed by some of my college mates, but it was to a script that was provided by the speaker, who is a fellow of the Chartered Institute of Arbitrators. And I will watch the same skit again 20 years later in Malaysia when I sat for my award writing exams. I sat together with Dato' Lim Chong Fong. Actually, it was at his encouragement that I sat. Otherwise, I said, why do I want all this go through all the aggravation? And then when I sat for it, I went for the lessons, the classes and all, and have to do homework and stuff like that. And my children, my 2 youngest children who were still with us then, and they were laughing at us, laughing at me, say, my wife is behind, you can validate the story with her. Papa had to do homework now. Okay, now in the early 80s, 1980s that is, everything to do with the PAM contract form was parked under the practice committee. I don't know when was the first arbitrator appointed, but I know that it was Dato' Kington Lu, and I know that it was in the 70s. Other than that, I have zero knowledge about the whole thing. And also, I was just mentioning in passing to Dato' Mary Lim that the first arbitration case in the KRCA was arbitrated by an architect, Tan Eng Kiong. And I won't say that. The other thing that he told me, I can't repeat in public because I can't repeat in public. But then that goes to show that arbitration and construction arbitration has been synonymous with PAM for a very long time. I retired to Malacca in 1985. The same year I was appointed as an arbitrator in my very first case. I can remember some of the details because it was the first case that I came across, but I won't say anything more than that. Now, I felt that PAM at that time don't have any system at all. It was just the president appointing. And because arbitration being part of the contract clause was actually put under the practice committee. And the two co-chairs of the committee will just sit down with the president. And sometimes just because I was working at JKR at that time, so I just walk over to JKR after work, leave my poor wife at home, and sat at the room, and the president the sitting president will just sit with the two and then start talking about the relative merits and demerits of each person that they wish to appoint to take the case. And that was it. And I still remember in the 80s, there was one person who was not an architect and was appointed to arbitrate in one case that came in before the practice committee for the president to appoint an arbitrator. And he was the late C.K. Koo. He was the first non-architect to be appointed as a PAM arbitrator. And I know in recent years there was a lot of hoo-ha among architect arbitrators about the appropriateness of allowing non-architects into the PAM panel. And I think I don't agree with that view. You can argue all you go. Like Datuk Mary, I believe in diversity. I think I always think that the Tang dynasty. I'm a cultural heritage advocate. I always think that the Tang dynasty was the high point of the Chinese civilization, because the Tang dynasty accepts all people, all races, and all religions, and that's why Chinese civilization reached its zenith at that time, and after that it was all downhill. Okay, now I think, but there's one thing that was mentioned to me. I'm not looking at my notes. There's one thing that was mentioned to me by Eng Kiong very, very early on in one of my conversations with him in his office. That means my boss office. And he said that actually we have no business to be in arbitration because we are not even lawyers. But we know the PAM contract, and we have a sense of fair play as architects we should at least have a sense of fair play on site. Because you cannot capture everything in paper, in writing, every single eventuality in writing. So there will always be areas of disagreement. And he used the term quasi-arbitrator, and says we need to all the time arbitrate between the contractor, the employer, the subcontractors, the domestic subcontractors, and so on and so forth. But I think the better word to use there would be to mediate between the two, in order to give a bit more class to the term arbitrators. Okay, so he says that PAM got into the business because we are custodians of the PAM contract. Our pivotal position in the construction industry is exactly that, even though it's a QS that does all the work. I salute to his surveyor on there. So he says, but because we need to maintain our custody of the contract, we must get involved in arbitration, and it must be seen as a service to the industry, and it is not primarily a money-making proposition. Now, I won't say that. I just want to make one remark. In the 1980s, when I was practicing, quite often when I was practicing started practicing as an architect, and also when I was working for the contractor, quite often the architect is seen as some kind of demigod, whose decision and everything, right or wrong, must be right. And I always feel very uncomfortable with that. And Eng Kiong told me, you are right to feel uncomfortable, because architects have no business to behave as if whatever their pronouncement is right. So I think this is an era at that time when I entered when I had my first arbitration case, it's an era that there's a paradox, oxymoron as it were, that the supposedly impartial administrators of the building contract, but then often perceived by everybody in the industry as favoring the employer who pays his fees, it has been asked to arbitrate in any dispute between the employer and the contractor. Those days, very few disputes between subcontractors and contractors. It's always between contractor and employer, and it almost 90% of the time overpayment. Now, that's my little trip down memory lane, and I feel that quite often when we're talking about the topic given to me is when the train derails, responding to scuttling tactics. Now, quite often, I think that the whole issue about delays in arbitration are actually own goals, to take a football terms, since we already started with mixed metaphors, train derailing and scuttling, which is actually a maritime metaphor. So I think they are actually actually own goals. The causes of these delays start at the very beginning, from the administration, as Daniel in his context note to us tried to point out to every one of us, that there has been weakness in the administration of PAM institutional appointments. There's sometimes I won't go too much into that. And then there's also appointments. I will bring a case up later that tells you why everything that comes in automatically was appointed an arbitrator without arbitrator is appointed without actually scrutinize the details of the case, whether even though there's an arbitration agreement in place, whether it is suitable for it to be arbitrated. So there's also busy advocates. Lawyers are very busy, especially if they are also involved in litigation. And quite often I have hearings and meetings that were postponed or asked to be vacated at the very last minute, at the very, very last minute, because the court has mandated appearance with, the judge has mandated the counsel to appear before him on certain issues, and that clash exactly on the same time. I'm not a lawyer, but I'm on the disciplinary board of the bar. so careful, Then there are also very busy arbitrators. In those days, I think the appointment of arbitrators were not systematically looked at. They are not systematically looked at. And so some people get more because they are familiar with the people who are making up the list for the presidents. And I think later day, I don't hear very much about presidents talking about the relative merits of each arbitrator. Unlike the early days, maybe because I'm out of touch. Because I semi-retired to Malacca, my hometown. There's also mismatched arbitrators. I've seen that more than once when arbitrators talk to me about their problems. I was wondering, why did you take that up in the first place? But be that as we may lah. So when the train derails, and I like trains, I go on train journeys just for the fun of it. But fortunately, I've not been to one that has derailed yet. And so insofar as the whole delays is not the fault of one party. It usually starts with the administration. If the administration is wrong, you start on the wrong foot, it can lead to more things in the future. It can snowball. But it's also got to do with the appointment system. It also got to do with the people that are involved, whether they're committed enough to the case that is before you. And I want to bring before you one unusual case. This case, in the late 1990s, I was appointed to a case. When I when I called for a preliminary meeting, they said I need at least 2 days for the preliminary meeting. Shock and awe. And the reason why is that is this: they have a letter to each other, signed off by each other, that there will be a contract between each other. It will be a domestic subcontract and a main contractor for the construction of a high-rise hotel. I won't tell you which hotel it is. So there were no documents in exchange. All it was that they sit down, they look at the architect's plan, they look at the engineering plan, and then they base their whole agreement on the contract sum from there. The engineer's plans was more or less there. The architect's plans were changed several times already from the time when the tender document that went to the main con, who was a respondent in the case, and it was used as a basis for calculating the contract sum. And for some weird reason, the engineer and the architect was not involved in the discussion of this domestic subcontract, which is in all in the usual case quite ordinarily, except that the construction structural plans are not ready yet, and it was supposed to be one of the first precast concrete high rise in Kuala Lumpur. So there was no real documents other than the exchange of letters that says you are my subcontractor, my domestic subcontractor. You will do the work. At the end of the discussion, you will do the work for X amount of money, and PAM subcontract form will be valid, including all the terms and conditions therein. That's it. So when I first meeting, I look at two of them and says, what exactly is your contract with each other, other than the contract sum? What are the works involved? You say, these are the works involved, and they bring up a stack of pre-exchange of letters, documentation, and another stack of drawings, and then a smaller stack of engineering drawings. And I said, this is it. I said, but exactly what it is. So it was a very strange experience for me, because they said, can you help us to narrow down the scope of works that we are supposed to agree on? So I tell you, this was like going through a tender interview process between an employer and a contractor. I went through 10 days of that. Now I'll tell you who the representative. The subcontractor who's a claimant is an Australian company, but he's using a senior counsel from Singapore. The main contractor, who's a respondent, is a German company, but he's using a QC from Australia. So I said, at the end of the day, I was wondering how all this works. I only found out on the last day, before the hearing, just after the hearing completed. And they were actually flying in. That's why every preliminary meeting is 2 days, 2 days, few days, 2 days. 5 preliminary meeting, 10 days. You come and work out how much cost is involved. Especially you have a QC, they were called QC at that time. Okay, so you work out the cost. So what is the conclusion of this very unusual experience? There was a block of hearing dates, agreed. The managing director of the claimant was the first witness. There were no witness statement, by the way. So he was, there were witness statements, but there was no response to the witness statement in a sort of rebuttal. So the managing director was cross-examined by the QC. In one day, he only covered, according to the QC, only one part of 10 questions he want to ask, 10 issues he want to ask the claimant. So I said, okay. The only lesson other than that I remembered, other than the skit that was put on in 1976, was this cautionary tale by the arbitrator speaker on that day. He said he had the misfortune, he's used the word misfortune, of presiding over an arbitration case between two public listed companies on the London Stock Exchange. About halfway through, he tells parties that it's best that you settle, because he did not think it's worthwhile continuing with the arbitration. Parties refused. A year and a half later, he says he handed down his award, and it is sad to say that both PLC do not exist anymore because they both went under liquidation, mainly because of the cost of the arbitration and the cost of the award. So this is one lesson that stuck to me very well, that I do not think that dispute needs to be litigated, whether in an arbitration or in the courts, and that mediation is actually the way to go. And okay, so that was in my mind when I finished the first day of hearing, and then I brought this point up before the two parties, as well as and before the senior counsel, the senior counsel and the QC. And I says, why don't you all talk over things and see whether you can come to a settlement? We will continue tomorrow, irrespective. So that night, all of us seems to stay at the same hotel. So that night, when I was going out for dinner, I saw the two parties haggling in the Pan Pacific in those days. Their business center is a glass box in the foyer, and they were there. They were all there, talking. The next morning, we start at 10 as usual. The QC, on behalf of both parties, says, can we recess the whole proceedings by another 2 hours, and I will give you a statement that you can use it as a consent award. Okay, long short. Claims, counterclaims came to tens of millions. What was the settlement of the consent award? I got it. I look up my award, my copy of my award, 225,000 ringgit. They came to their senses. I actually mentioned to them, you have the pleadings, you have the facts of the case, you have seen the evidence, you have seen the documents. You tell me how much is it what is the realistic amount at stake? After one night of discussion, they come up with this figure, 225,000 to be paid by the respondent to the claimant, and each party to bear their own cost. I don't know how much time I saved there, but I think quite a fair bit. But even then, that took about 3 years. Now I want to go to, okay, this is the one, at the end of the day, it was a amicable conclusion. The fastest and slowest PAM arbitration cases. Daniel's record went back 10 years or so, correct? Huh? My personal records went back 40 years, roughly 40 years, 26 years started, 26 years started. And I personally have one case that was settled in 2 months, including award. One preliminary meeting. And what happened is basically the two parties were this is where administration come in. The two parties were actually Sindiran Berhad. They were dealing with each other under Sindiran Berhad. And both were based in Johor Bahru, and I'm in Malacca, and hardly go to Johor Bahru. I thought, I don't know anybody in Johor Bahru. Turned out the managing directors of both companies were friends of mine. So when I went, I said, since you are both in Johor Bahru, we wrote letters in those days. We didn't call each other. So I went down. I said I will come down and meet you I meet you at the hotel, this hotel that I'm staying in, and when they both walk in the room, I said, hey, what are you two doing? You say, we are the parties to the arbitration. But both of you are good friends. You say, yeah, but I know I owe him money. Well, I don't know how much. I don't agree with what he wants from me. So I say, okay, you obviously know who I am, because I don't know who you are, but you obviously know who I am. So what exactly? He said, there were extra time. The project was cancelled. There were extra work done, and I know I have to pay him for the extra work, but I don't know how much to pay him, and he wants an astronomical amount of money. I said, okay, I'm an architect, you know. I told him, I said, I'm an architect, you know, and I probably could be able to cost the time cost on that, and then you give me your delivery notes on the drawings issue and things like that, and I work out the cost for you. Is that acceptable to you? Oh, he said, yeah, go ahead, do that. I said, the total fees will be about 1,000 plus. Back in 1990, because that's basically it. I went back, I said, I'm not going to do the thing. I'm going to ask my staff to tell me how much time. I used his salary, my most senior draftsman's salary, to work out how much money is involved. And I charge my expenses and maybe a day's fees. In those days, I think a day's fees was 125 ringgit an hour at that time. So you work it out. So it's not very much. I remember it's just about 1,000 plus. But like I say, that lesson in 1976 was very clear in my mind. Then the long case in which which went on for 17 years. I took over the case because of the demise of the original arbitrator, who died 3 years after the case began. And then one thing led to another. It was 14 years before I hand down the award. In between, one counsel went for a course that takes 6 months, 9 months or 6 months. And the owner, the claimant, disagree or have a big argument with his counsel, not once, 2 times, 2 counsels. So the third counsel took over. The first counsel was dismissed. Second counsel was dismissed. The third counsel is now a sitting High Court judge, a Jewish JC, and then the fourth counsel is a very eminent arbitration lawyer in town. The advocate for the respondent is now a court of appeal judge. So you can you can narrow down your names there. So this, as far as I'm concerned, and then they took a year off to negotiate a settlement. And from what I understand, only recently, that the settlement amount was not very far from what was offered to him. And I mean, can you imagine the expenses over 17 years? It was just crazy. This train definitely did not derail because of any conduct that is benign, or not so benign intention, only of any malicious intentions, but because of events and possibly because of personalities. Now, I have put in here a pause for reflection. How come I cannot go on? A pause for reflection, but I won't talk about reflection because I'm running out of time. And very quickly, I want to talk about the scuttling tactics, a classic case. I've seen scuttling tactics in at least 3 cases in my life, but this take the cake. I was the second arbitrator on the case because the first arbitrator was told that his appointment is going to be challenged within the first month. And then, but he never challenged his appointment. So as a good arbitrator would do, he keep reminding people there's a preliminary meeting coming out, set dates. And then finally, after 9 months, After 6 months, this is where it's so obvious that there was according to the submissions, after 6 months, he fixed the date. Based on the date that the respondent council proposed and the venue that the respondent council proposed, it turns out that on that date, the venue is closed. So he wrote another letter, says, okay, this is 2 months away, the venue is not available, can we hold it 2 weeks earlier? Nope, not possible. And he didn't, the first, if I may just refer to my notes, the first hearing, preliminary meeting was about 9 months later. Then in April 2017, there was a new solicitor appointed to take over the case. And I was appointed in July 2017, out of a list of 4 names as mandated by the court to PAM president. You either choose one of the, both of you either agree on one of them or not at all. And I was apparently the only one that was agreeable to both parties. Fine. Okay, so if you look, I don't want to go any further, but you look at the pleadings, postponements, vacating of dates, and so on and so forth. And 2 weeks before the hearing was supposed to start, the respondent counsel says, I'm recusing myself because I cannot agree with the respondent on the direction of the defense. So I said, fine, you will remain, I told him, you will remain as counsel on record until such time a new counsel is appointed. The other party came back and says, oh, give us 6 weeks, we will find someone to replace him. Okay, fine. 6 weeks passed by, he came. He says, we couldn't agree with the replacement counsel, which I heard from the grapevine after the case was over, was the first counsel that he appointed in the first place. Then he asked for 2 more weeks. I said, okay, these two more weeks is an absolute limit I will go. Because the claimant's counsel is making a lot of noise, and is insisting that the case should go ex parte. I said, if you cannot come up with a counsel, I'm going ex parte. Mind you, the respondent it's a big project, no? The Tan Sri, with all due regards to Tan Sri, the respondent chairman is also a Tan Sri. And he only sent someone called, I don't know what position she is. And she come and basically says, I'm only mandated to say this. Everything else I can't say. So I said, never mind lah. Then I give the PAM, I think the PAM rules are actually excellent, except for the revisions that was proposed by Daniel and a bit of correction of text and things like that. They were all in good and ready to go. There were sufficient default powers to go by and stuff like that. The only thing I think now we are talking about money, right? The payment system as well as the new appointment system for simple cases and things like that. I think that can work. Lump sum can work. Especially in single issue cases, lump sum works very well. I had one recent case which was documents only arbitration. The lump sum fees was 20,000. Wrap it up, bao high. And it works very well. I spend just enough time because I don't have to look at anything in between. I just accept all the documents. At the end of the day, I look through at once, and that's it. The submissions, both of them were actually quite competent arbitration lawyers, counsels, and they actually summarized the issues for me and things like that. And then I look at it, I look through the evidence, and I wrote it's just one issue, and it was all settled. I have other things written down here, but my time is up. I think this was a scuttling one. The coup de grace is always last minute, counsel recused himself. and they were afraid that I will say, okay, counsel recused, I wait for you to appoint your new. But I'm not playing by that game, sorry. I think I have enough gumption after this year, after all these years, to be confident enough to stick my neck out and say, we go ex parte. After all, this is not the first ex parte case that I will handle. Thank you very much. I think I just leave things as it is now. I got 3 more pages if you want to hear. Thank you.
Thank you, Architect Tiong, for sharing your perspectives. We now move to the panel discussion where our speakers will explore today's discussions. The topic for this panel discussion is efficiency as the way forward. I am pleased to invite all speakers to the stage. The panel discussion will be moderated by Mr. Chan King Ho. Mr. Chan, I hand over the session to you.
Good afternoon. Yeah. So we have a panel of very eminent speakers, very interesting, illuminating, very animated. And it's time for us to take the discussion a little bit further. And let's keep this informal. If anybody would like to raise questions, it will be best that questions come from the floor, right? So that we can have more participation. I'm sure every one of the speakers are more than happy to address any questions that come from the floor. And let's start. Do we have anybody who has got a pressing question for the speakers? A challenge for the speakers, something that you totally disagree with, or something that you totally agree with? Anybody? All right. We always take some time to warm up. That's okay. So I'll start the ball rolling. And then as I start the ball rolling, if anybody wants to chip in, give a comment, ask a question, raise a hand, and I think the room is small enough, you can raise your voice from wherever you are. All right? So we've been focused on speed, right? Efficiency as the way forward. Tan Sri asked the question, is arbitration really faster and cheaper? Dato' Mary asked, when is a delay? So let's start with facing some realities of statistics. Architect Tiong told us that his fastest case was 2 months. Slowest case was 17 years. The statistics of 10 years given to me by Daniel was 4 months and 8.4 years. But the important one is the average, because we know there are outliers, right? There are always issues. The important statistic is the average. And the average is 3.5 to 4 years. So let's start by asking the speakers, is that time span acceptable? And how does that compare based against AIAC statistics, against BICM statistics, or even against the courts? If anybody has some sense of the statistics, because the average in PAM is 3.5 to 4 years. Anybody wants to take that up? Oh, we've got 2 directors of arbitration centers. Come on.
I'll take that out first because BICM doesn't have any statistic.
I see, okay.
But coming back, I presume the 3.5 to 4 years is after the close of pleadings, right? Or award?
Up to award, yeah.
Up
That
to
means
award,
from start of appointment up to award, I guess.
Oh,
Or
okay.
start of notice of arbitration up to award.
Oh, okay. To me, I mean, I've done not many, but enough. I had one was quite substantial, but I was able to finish in 2 years, but mainly because the lawyers were really hardworking. That's where the problem is. But I think if you can get done in 2 to 3 years, that's very good already. But when I told other arbitration lawyers and all that we would finish in 2 years, said that's very fast. That was one of my first cases I did. I said, oh, that's good. But I think if we want to be an alternative, I think 2 to 3 years must be the benchmark. Mary?
I don't have the statistics with me, but I know it's healthier than PAMS. Confidently, I can say that. I look at the ones which are, as you say, we've got the very old ones, and I always ask, what happened? What happened to take so long? And thankfully, the answers are not due to, for me, very importantly, the centre not pushing, administering it properly, or even the council or the arbitrators. It's frequently this problem called insolvency. They've decided to play a parallel game, and that scuttles the arbitration proceedings. So it's a lot healthier. And I also see arbitration as a push to an early resolution. So frequently I have got the tribunal composed. They're all ready set to go with all those beautiful directions that Tan Sri David mentioned, and the parties are talking in that glass door that Architect Tiong mentioned. And the next thing is a consent award.
Well, of course, when Tan Sri says that he's got a case done in 2 years, maybe I would like to ask CIPAA, because is that 2 years done because Tan Sri is Tan Sri, and council kind of still have to pander to, well, a very superior court judge? And how does that experience, would that be different for a private arbitrator facing the same constraints?
I think that's realistic. Unless you're, of course, on an expedited framework, then it's usually 6 months, and it's still doable, but that's party's choice. But if it's full-blown with evidential hearing, expert witnesses, 2 years is probably a good average, I would say. But, you know, when you're talking about the delays, sometimes it's delayed also because there are bifurcated hearings. So you have preliminary awards or, you know, on some issues, and then a second tranche of another hearing. So that could also cause greater delays, yeah.
So, not necessarily faster. Arbitration is not necessarily faster. I think not cheaper, because for the you pay lawyers either in litigation or arbitration. You pay experts anyway, but you've got to pay the arbitrator himself, right? So definitely not cheaper. And Tan Sri then raised the question: the real competition is the judiciary, right? And so we've got specialized courts today. We've got construction courts, we've got judges who are familiar with construction technicalities. So is it time for parties to at least get the option to delete the arbitration clause? And I'm asking about PAM contracts, because all of you have got arbitration clauses there, right? So is it time for architects to consider the option of advising clients from the start, maybe we should delete the arbitration clause in the first place? Anybody would like to give some feedback? Maybe architects. Oh no, Dr. Mary wants to give some feedback first.
I don't strike out that clause too early, because I think the courts are too cheap. Access to justice, I don't think arbitration is expensive. When you pick somebody and you have chosen wisely to be your judge, you know that value, you know that competency. Why has it got to come cheap? I think that's very important. And the court's pricing mechanism and its whole schedule needs a whole lot of rethinking. And you can see our prospering jurisdictions, other prospering jurisdictions have done exactly that. When you have corporates fighting, it's a different scale. The access to justice will come with and must come with a price. So to me, I think the Malaysian judiciary needs to sit down and rethink its costs. It's shot itself in the foot. It's made it too cheap. Everyone is coming through its front door and scuttling its own efficiency. So I don't think it's a case of arbitrators being expensive. So don't take out that clause. I don't care where you go, but you shouldn't go to court.
I was about to say the same thing, that you should not take it out. You can change the nominating person, but don't take it out. Not because of the reasons that you say, but I think also because if you don't state, because the arbitration clause comes with other clauses nowadays, and mediation is one of them. And I think more effort should be put onto mediation. And that silly case that I took on has no business to be for the arbitrator to be nominated at all, because it doesn't meet the criteria of an arbitrable subject. Because you don't even know the works involved and things like that. The basic ingredients are just not there. And the last comment I want to make is our PAM's application form mentions a lot of things, but there's one important thing in the rules that says parties can nominate their own, can not nominate, I think parties can suggest which arbitrator they want to use, or the qualities of the arbitrator they are looking for. Inevitably, the claimant has never done so, and not surprisingly so, because it's not on the form.
Well, just an update on Dato' Mary's. Okay, give me 1 minute. I'll come to you. Just an update on Dato' Mary's comment on the cost, which is that right now the costs are being updated. We are facing 80 to 100,000 of costs for a trial in the High Court. That seems to be the trend nowadays for a full trial. In the construction court, at least about 100,000 from Justice Azlan, right? So I think the costs are being updated. No longer are the days when we are talking about 15,000, 20,000. You go through a full trial, you get a $20,000 cost.
The highest costs I awarded was just under $1 million. And I remembered, and this is probably 18 years ago now, Justice Lim Lan, in her High Court proceedings, I think gave 1.2 million.
Wow.
That time ago. So don't think the courts we're only talking about filing fees. The costs can be quite astronomical.
Sir, you have something to comment?
Question. Thank you. Sorry, Joseph, architect. Your question was, should the arbitration clause be struck out? I think probably not, but I would like to ask the other question. Now, I was trained to understand that arbitration came about, ADR came about because it was cheaper and faster than the legal process, the courts. But arbitration itself became very, very cumbersome, and that's why you had CIPAA coming in. But even then, with CIPAA, with set fees, set time frame, reality is that there are a lot of hidden costs because a lot of clients now have to employ lots of lawyers. Now, so my question with regards to the PAM form, should PAM form actually have an arbitration clause, but for claims below a certain amount, accept the case, accept whatever is presented, but exclude lawyers from the proceedings?
Well, I think I'm biased, but the other four are not practicing lawyers. So why don't we have the speakers address this issue? Should legal representation be excluded?
In arbitration, but I've walked past arbitration cases being held in PAM, and I see lots and lots of people and lots of documents. I can only assume that complicates and prolongs the process.
Anybody wants to take that up?
When Chong Fong was first instance judge and finally sat in the construction court, he deployed the services of his old friends to sit as referees, the special referees procedure, and he got them to agree on a lump sum. And I believe the lump sum was 25,000, 30,000, and suggested to all of them that it's national service. the people I think he reached out to, he didn't look at law as being a necessary qualification for as an arbitrator. He just wanted somebody to get the job done. The reality, I love that suggestion, and I think it is good. Your low claims or the lower value claims, you should not complicate it. You could package them differently. I think the expertise doesn't really matter whether it's legal, but the correct expertise is more important. And you fix the costs. And I'm sure there are, and that's on a condition that parties must be prepared to open up and accept a younger arbitrator. And if you are prepared to compromise, I think that fixed bracket with perhaps the junior or wannabe arbitrator could be the right place to start.
I think a caution that comes straight to my mind is that no matter what is the value of arbitration, the fact is there is an avenue available for a challenge of the award in the courts. And if we start off by saying we limit or exclude legal representation, right, because of the value, then the problem is, will the award be sufficiently protected from a strong setting-aside challenge? Yeah. Of course, the threat is also there with representation, but I think legal representation safeguards the process a little bit because we deal with issues and we fully submit, and therefore a proper decent arbitrator who just who respects the process, as CIPAA says, will be able to safeguard the award quite effectively. But if we don't, then we have a potential of the award being set aside being higher, and if that is higher and it gets remitted back, it adds to the cost anyway in the long run, because the final arbiter of the arbitration award is still the courts at the end of the day. Of course, not on the merits, but a judge on the due process and how well the award has been written and safeguarded and protected, the rights of parties are protected, the final arbiter is still the court. So we unfortunately cannot run away from this reality. That's my personal view. Right. But yeah, parties have, of course, one of the benefits is you get a choice of your judge, right, in an arbitration. But the reality is, unless the proposal is Tan Sri David Wong, Dato' Mary Lim, CIPAA, the reality is parties do not agree on each other's choices of arbitrators. So is that really a benefit of arbitration in the end of the day, because parties just simply do not agree and do not trust each other's choice that is proposed? What do you guys think?
Can I tell you what I think?
Yep, of course.
Because in the response form, in the application form by parties, quite often they say, have you approached another lawyer, another person as arbitrator before? And the name is mentioned there. I'm surprised that even then, very eminent names appear in there. They were rejected. I've come to the conclusion. I've been approached to put my name onto. I've only have two cases which was appointed by parties. Every other case that people write to me and ask me, can I put your CV on as the arbitrator for this case that we are handling? Inevitably, I know for sure I will be rejected. And when I look, is it Tan Sri has been rejected too.
Same. Tan Sri, you have been rejected as well?
That's the reality. One party suggests, the other party object for the sake of objection.
So that takes away the benefit of arbitration in the first place, right? Because at the end of the day, you don't get your choice.
Actually, if you ask me, I think the PAM rules were quite on the spot, with the provision for parties when they're making a application to suggest the names of arbitrator or arbitrators on the panel, or otherwise, or the qualities of arbitrator that they're looking for. And that, I think, should be formalized in the application form, so council could take the liberty to fill it in, and that gives a lot of a lot of guidance to the administration in choosing an arbitrator for parties to choose.
Let me raise a very interesting discussion I had with Anthony recently, which is the use of arbitration as a weapon. Right? So there's an arbitration clause, and some parties insert the arbitration clause. They insist, for instance, to put it to Singapore, higher cost, 3 times, 3.5 times, right? Number 2, 3.1 now. Thank you, Kerajaan Madani. Number 2, they insist on the 3-man panel, 3-person panel, right? Which means the cost goes up again, right? And we're talking about being seated in Singapore and so on. And sometimes they put this clause in knowing that it's going to be prohibitive for the smaller players. Because how are you going to sustain an arbitration fight when the cost is so high? When they seat it in London, they seat it in Hong Kong, they seat it in Singapore, they put 3-man panel onto it. And so they use the arbitration clause as a way to deter any disputes, which gives the party having more negotiating power a major advantage.
In instances like that, the contracts are maybe 20, 30 million. And then, so often, the retention, you never see it again. The retention is always very close to the cost of the arbitration. So you think very hard about wanting to, go for it. And these are kisah benar. So Mary, is that a parang?
I think while arbitration clauses have their inherent problems, depending on which lawyer you go to and whether that lawyer is up to date or has relied on the wrong AI. So it gives you all this horrible, I would call them pathetic arbitration clauses. I like the way institutions, and I think PAM, everybody else, is keeping that resolution door open, like a revolving door, mediation, always still an open option, that it's not a step ladder, that while you may get on with the arbitration or begin to get on with the arbitration, that mediation is a real viable option. And I think one of those discussions, I'm sorry to come back to the legal people, the judicial perspective. Some people think that arbitrators who are ex-judges are supposed, your question earlier, have that edge, and they think that that's an added factor as mediators. So mediation perhaps is the cheaper option, but here comes another bit. The mediators are saying, unlike arbitrators who only open the file on the day of the writing of the award, the mediators know everything before they see the parties walk through that door, and therefore they should be equally priced. So that conversation and negotiation is still on. But the point I want to make is that mediation or other alternatives should come as your cocktail of opportunities for resolution, that it's not once you go through you can't go back again.
I was very impressed with Tan Sri raising his use of AI, right? And he gave me ideas, right? Now I just received a 400-page submission from an opposing counsel. I'm definitely putting it through Copilot. Summarize for me. So Tan Sri's use of AI is quite impressive, and the question is, how far can AI go towards lowering the cost and making the process faster for arbitration? For example, in the American Arbitration Association, construction disputes below 25,000 US, they now use AI as arbitrator, not as helping you process and all that, as arbitrator. AI as arbitrator, and then a human to just look through the technicalities to make sure that the technicalities are checked, and then that's it, the award is good to go. The human does not make the decision. And of course, I have a good friend from law school who's teaching in MMU and who's very interested in AI. He says, actually, you can manipulate AI. I had that discussion with him, and he says you can manipulate the AI because as long as you know how the large language model is crafted, use of the right keywords will lead you to specific decisions. So how far can AI help us? Tan Sri, maybe you are the AI champion in this panel.
I wouldn't say I'm the champion. Of course, you know, when you say you can manipulate, that's a reality. That's a reality. That's why, you know, it always goes back, the human touch. At this time, I don't think you can get out of it, right? I remember when at the High Courts of Sabah, we use AI for sentencing. Sentencing. There was a hue and cry about, wow, you're taking away the discretion of the magistrate and all that. My rebuttal was the AI was only used as a guideline, right? And actually, I invited lawyers to make a constitutional challenge on the use of AI. Unfortunately, it didn't. The lawyers did not take a constitutional challenge to it. But of course, in America, they took a constitutional challenge to it, and they said, no, it's just used as a guide. But coming back to the question of AI making a decision, you know, I think in Brazil or somewhere, because there's so many outstanding cases, for the lower value claims, they use AI. That's it. Of course, we have to change our law. We have to change our how we dispense justice. That those lower claims, you know, and we're talking about, you just put in the machine comes out with that's it, right? But I don't know whether in my lifetime, but I envisage a time that AI would you know, maybe do about 95% of the work for us, and you know, and the arbitrator just sign off. But that doesn't mean that the arbitrator doesn't take responsibility. You are signing off. You still have to go through what the AI come up with, right? And then say, oh, that's a reasonable decision. That's a decision I would have made, and sign it off. But the time for me to prepare this award, probably, you know, cut out about 100 hours of looking into it. What's wrong with that? What's wrong with that? At least that the people coming to seek justice, you got it quick, right? That's my sort of say that time.
Keng, I'm sorry to take the mic again on the floor. I want to share this experience of my last year or so, visiting arbitration centers in China and observing how they do construction arbitration. Construction, to the extent that in the Hong Kong arbitration week end of last year, categorically China said, we will not adopt statutory adjudication simply because we don't need it. The resolution of disputes are so effectively done through arbitration. Why? Perhaps it's because of the numbers. But I will tell you, if you put the volume of cases aside, the value of claims in arbitration in construction disputes in China is no different from ours in our landscape. But the institutions insist that they have to be completed in 6 months, and they cross-fertilize or cross-support from high value to low value all the expenses. Transcription is not farmed out to another body. The whole institution feeds you from that single payment. They feed you so that you don't go and have to call Grab for your food. And the transcription is done immediately. And here is the sad news. the arbitration award is also templated. It's ready. As the evidence is being collected, it goes through the AI that holds services, and the draft award is ready for you to walk through like you're buying your ticket in the London Underground. If you make this decision, these are the pieces of evidence. If you make that, these are the pieces. If you want this, this is the calculation. You don't believe me? Go and check Shenzhen International Arbitration Centre. That's where they have reached. So I think we can address the concerns that was raised just now. We just have to have that will.
That sounds so impressive, but we'll be quite happy with a good canteen in AIAC as a start, Dato' Mary.
Unfortunately, that doesn't fall under legal affairs.
Okay, I also want to make this a bit more practical. I want to make this more useful for people in attendance. The number one scuttling tactic, I am told, is a failure to pay deposits. Right, that's the number one scuttling tactic. So maybe let's just run through, and we've got all very experienced arbitrators in our midst, run through how do we deal with a claimant who refuses to pay a deposit. Usually they have lost a Section 10 application, right? So they were unwilling parties to the arbitration in the first place. So now they refuse to pay a deposit even though they are the claimant. And number two, how do we deal with a respondent who refuses to pay the deposit even though they have a counterclaim? Right? I mean, if they don't have a counterclaim, then you just make the claimant pay for it, right? But even though they have a counterclaim, they refuse to pay the deposit. How do we deal with these situations? And this just to bring it down to be a more practical level for people who are arbitration practitioners in the group. Oh, Architect Tiong, come on.
I have one case that, there are two cases I'll bring up. One case that, unfortunately, I didn't collect enough deposit. And the case, I'm still holding a lien on the award. I managed to collect maybe 90% of my fees. But the other 5%, I think I can wave it goodbye because I've been holding the lien for about 10 years now. No, 10 years now, correct. so I think, but I already told PAM to just close the case because I will not make any more claim against PAM out of the security deposit and things like that. But I have one case, interesting case. Some of my interesting case, most of my interesting case involve architects for some reason. And this interesting case involved a very prominent architect who is no longer in architecture, but rather in property development. And he has quite a big organization. So when he was sued for, when the claimant put in a claim against that company, he sent his in-house legal counsel to attend the meeting. The in-house legal counsel says this and this we agree, but this and this we will not agree. Then he says, okay, then I said the next preliminary meeting, I said this will be the agenda, and can you confirm everything and make sure you pay your deposit as well. Silence for a long time. But in the meantime, I keep pushing. After about 6 months, I said, that's it. Every month I push I write a reminder letter. After 6 months, I forget about it. I asked the claimant, what you want to do now? The claimant says, can we go ex parte? I said, go ex parte by all means. So I wrote to both parties, tell them this case has been claimed, is going ex parte. The claimant has agreed to pay all the charges and monies that is due from the as per our rules. Whatever is due from the respondent, the claimant will pay. So it went on, and then at the end of the day, the claimant have 4 witnesses. We went through the 3rd witness. Suddenly, because I kept the respondent informed all the time, suddenly he turned up. The first time I saw him. And I knew what he looks like, but that's the first time I saw him. And he says, oh, I need to restart the case. I said, no, I'm not restarting. I already told you at the beginning. I think the rules are very clear also that you start as and where we stop. And you can continue after that. I said, but I can ask the goodwill of the claimant to allow you to, although we are coming to an end, to allow you a bit more time for you to prepare your case. And that's all. So I give them 2 months, and he continued. The case went to full hearing. He brought in another two witnesses. I hand down my award, and the award, of course, was against him. And then he challenged the award in court. But I still won't mention the names. You all check it out yourself. And the judge used a famous word, procedural skirmishes. Before the arbitrator should not be and then he also claimed that he has no right. He was not given the proper avenues for natural justice. So the judge also looked in his comments and says, look, natural justice has by and large all been codified. So there is no reason why, if you say you have been deprived of your natural justice, please state where. You have not stated where. I've asked your counsel has not said where. And then in the closing remarks, he says, I read his award. He have attended to every, and I find no fault in it, even aside from the fact that I'm not supposed to look into the facts of the matter.
CIPAA, maybe you could throw in your 2 cents here.
Sure. But there's a problem with asking me to say something. I'll speak on something else as well. Okay, but the thing is, I'm not terribly familiar with PAM arbitrations, but I just speak generally. I actually have suspended arbitration where the deposit's not paid by the claimant. Where there's a counterclaim, it gets more tricky because they get to still defend even though they haven't paid their portion, but it's up to the claimant to satisfy the defendant's portion. If they were to proceed, the counterclaim may not proceed. But can I ask you for permission? I was listening to all the earlier questions and answers. I just wonder if I just may suggest a couple of things, because it is for moving forward and whether we can borrow things. So the gentleman over there talked about having no lawyers in the room, and what comes straight to my mind is that PORAM does that. The Palm Oil Association, and maybe if you want to look at something, see how it goes, and they've been doing that for many, many years. But it does affect the quality. It does bring up the benefit of having a lawyer in the room is they will pick up, and it's a check and balance. It picks up on bias, picks up on many, many things, including enforceability and so on. What you may consider is that for certain value claims, there'll be each party bears its cost. So it's up to the party whether they want to engage a lawyer, and that will be its own filter. As to the point about it's always the other party striking out my party's nominated candidate for arbitrator. The one thing I've seen happening very successfully is then the list system. A party gets to put 3 names or 5 names, up to you, and then each party writes their own, so it becomes then a list of 6 names or 10 names, as the case may be. Each party gets to only strike out X number. They can only do 2 strikes or 1 strike, as the case may be. So you cannot strike out every name that the other has given, and you're asked the party to rank in accordance with their preference, who it is they rank first, second, third, fourth, so on. And then, of course, it's the appointing authority that decides finally based on that. So parties still have invested intention into the process of appointment, and they know that, look, you can't just tactically knock out every name that comes about. That would be my other thing. And about taking out arbitration clause from PAM contract, I would tend to agree that you should keep it in, because I come from the maritime industry, and I see actually the maritime industry having arbitration clauses and still waiving it and going to court. But they do that at the point the dispute arises, and they look to see who's sitting in the Admiralty Court. Because you can have new people sitting in the relevant specialist court who will have a learning curve. And what you get from an arbitration is real expertise, people who are hardcore, who know what they're talking about. Makes it much easier, much faster, cheaper in the longer run if they get it right. So those are my, 2 cents worth.
I'll offer you some answers from the three hats I've worn. What do you do when those deposits are not paid? It's frequently forgotten that under Section 10, it can be on conditions. Frequently, counsel think that they've won, they've staffed the case off from the court's list, and okay, it's now arbitration. And that's where the problem starts because of non-payment of deposits, regardless the amount. Conditions should be imposed. I've actually written a decision on it, that the court should be invited to stipulate that parties get on with the arbitration within a certain time frame, and that if any party is delinquent in deposits, etc., that they are at liberty to go back to court for revisit on the matter. It's frequently forgotten. I think it's 10C or 10B or one of those provisions. So that's my judicial hat that when I looked at that problem. The second is arbitrators. It's already been pointed out, the power to suspend. Frequently, unfortunately, arbitrators don't want to do that. They just like to keep it going, thinking that if they suspend, that's the end of that brief. They can't, they'll have to wait a long time. And I will hope arbitrators don't look at it from that perspective, that if it's suspended, they are actually ready to take another. From the institutional perspective, the 2026 rules have included the provision for the institution to suspend. So because if the arbitrators don't want to get on with that kind of decision, like Singapore, we cannot keep that arbitration as a very bad statistic, or it discourages people from going to arbitration. Separate deposits when you have counterclaim is something that I have implemented quite aggressively, and I think the reaction on the ground is people are not quite happy about the fact that they have separate, they have to pay separate deposits when they're counterclaim. But I think because these are your choices, these are the provisions, let's see where it goes. But it will come back to exactly the same point on the power to suspend.
Suspension I think is fine and good. The problem is when arbitrators threaten to...
Sorry, it's deemed terminated.
Yeah, if arbitrators terminate the proceedings, then that's a problem because one party is willing to pay, right? But the other side is not willing to pay their part. And then if the arbitrator terminates, so if a claimant who loses a Section 10 refuses to pay, and then the arbitrator terminates it, you basically compel the respondent to go back to court. The very thing that the respondent fought against in the first place. And so suspension, I think there's a need for arbitrators to understand, yes, you can suspend, but maybe be careful about terminating the proceedings, because if you terminate, then you're forcing parties back to court when it's patently unfair for the respondent who won a Section 10 who is now forced back into court. Inequality of arms. CIPAA raised this issue, and it's a very real issue. How does an arbitrator sitting in a case deal with parties who are unequally represented? And of course, CIPAA gave very good suggestions. That's I'm going to raise the COVID Act, or I'm going to raise this authority. But there are times when the inequality is so bad, CIPAA, right? I have raised authorities before to parties, and the authority clearly cited the claimant. It would have helped my job a lot if they just submitted on it. And then the claimant comes back and says that authority is irrelevant. And then the respondent, of course, very quietly says, "Oh, I agree. I agree. I know very well the respondent knows it's not irrelevant." How? And then what do we do with it? As an arbitrator, do we just say, "Oh, too bad. It's just going to go into my historical narrative that I told you to look into this federal court decision, and both of you decided to tell me it's irrelevant, so I'm just going to ignore it, even though it is the law of the land. You know, what do we do with it, CIPAA?
Well, if you've actually invited the submissions and they've given it and they've said it's irrelevant, then it's still open to us to speak about it because we have asked for submissions and we're entitled to. So it becomes a foreseeable surprise if I finally decide on it and it wasn't irrelevant, yeah, but opportunity was given. It's not in breach of natural justice. That's what I would do. But what I have had many a time is where, you know, you've called for it and they still don't respond at all. They still don't respond. So they don't feed you with a case. I cannot go behind their back and get the cases on my own strength. That, I think, would be overstepping my boundary. If they don't, I mean, the parties were then not served. And it's a shame when parties are not served by their counsel. But so be it. That's the bed that the party lies on.
You think it is wrong for you to put forward a case and say, look, I'm aware of this case?
Well, so I know of
I invite
tribunals,
submission?
yes, who have put the cases and said, I have actually stumbled on this case, can you comment on it? So that's the other option. But if you don't, because you've closed proceedings or whatever else, then it stops there, I think. Yes.
I have a question. If two parties have agreed to arbitration, President of PAM has appointed the arbitrator, then the preliminary hearing is held and then things are moving on. But then the claimant is a subsidiary company liquidated. So they can't proceed. So I asked them, what do they want to do? They said you have to wait because they have to go to court and settle all those matters. So what should the arbitrator do when this happens after 2 years?
As in, they cannot settle the matter even despite waiting for 2 years. Or the
Nothing
arbitration
moved, no ex parte, no nothing. Because the liquidator was asked to get permission whether they want to proceed. No answer. So what happens?
This is quite a frequent phenomenon. I don't see any reason why in a very well-positioned letter copied to everybody or written to everyone, to the liquidator, I understand letters have been written to you asking for your decision on whether to get on with the matter. Can you please tell us the status? And if I don't get a response by such a time, can I take it as you've refused? So you take a position so that you can almost force the decision, because it also depends on whether you're dealing with the official, the government liquidator or the private liquidator.
I have nothing to add to what Mary says, but come back to what the CIPAA case discussion about. You come across a case and parties never refer to it. It actually happened to me. Actually, hearing finished already. I'm just looking at submission. And then they come to this case. I gave it to the parties. Of course, one party's relied on it, and the other parties relied but put it on the spin, right? I thought it was okay because the law has changed, right? During the arbitration, because the federal court case came down really recently. But I both submitted, and I thought that was the right thing to do. Could I get confirmation that was the right thing to do?
Well, it wasn't challenged, was it?
No, well, I don't know. I just sent the award 2 weeks ago, right? And the other thing is, what I found is, you write them to the award, and one case is not referred to by either side, and then you put it in your award, right? But that case does not talk about a new area of law. It's just another authority supporting a proposition. I know as a fact that lawyers have taken to court to challenge it for breach of natural justice because that case was not brought to the notice of counsel, so they had no chance. Fortunately, I know the court rejected that as breach of natural justice. So because it wasn't a new, like the case, the example I gave, that was a completely new statement of law. This is the case that overruled Sri Ramin, that Bajaya time. Right. So that case came to light after closest submissions already. So anyway, I'm comforted by CIPAA that I was on the right track, but just have to be careful. I mean, the using a authority which is not given to the councils, that cannot be challenged. At least in the High Court it was rejected.
It's good to hear that the High Court is rejected, and thankfully they've common sense. But we pick it up very often during technical review. We find arbitrators using their expertise, and to me, rightly so. Why should they be confined to only those authorities? But as a word of caution, this is picked up during technical review, and it's advised to the arbitrators that perhaps they might like to just add words like this is trite law or settled principles.
So I think Tan Sri gave a couple of situations. So it's a situation of a new case that does not change the law, but it's just additional. So I think that's fairly safe, but I still wouldn't do that because parties have given you other cases. So I would just use the parties' cases because the court will actually see whether it's material to the outcome. It wasn't material. It didn't change the outcome. So even if there's a breach, a technical breach of natural justice, it did not affect the outcome because there are other cases that supported the same proposition. Now, if it's a new case, and of course, then it's right to put it to the parties and say, even if you've closed up, it's just come out, can you submit on it, and then take it from there. The problem is, if we were talking about the parties who are just not responsive, the problem is then what you do, they just don't respond. I just think it's a bit risky to go on a limb on my own on that, even though if I had the backing of Datuk Mary here to say that it's okay, it's my expertise, I may not do that. I've given an opportunity, nothing came of it. I will find another way of saying it without referring to the authority. Coming out as a flow from the argument, but not using that authority.
So based on the feedback, looks like we will not see an award of a former CJSS being set aside, unlike the CJ of India and so on.
Thank you.
And Dato' Mary, of course, raised this issue of technical review, and I attended a talk on explaining the technical review process. Very, very fascinating. And I'm not sure whether PAM has the same mechanism in place, but maybe we could invite Dato' Mary to just give a very short explanation of this technical review, and maybe PAM can take this on as a potential suggestion on enhancing its ADR process.
Thanks, Keng Ho. Actually, it was something that I should have mentioned. And I think, CIPAA, you mentioned enforceability of awards. At the end of the day, you don't want your work to go down the drain. And therefore, the technical review or the scrutiny, depending on what phrase is used or adopted by an institution, is an added feature or service that an institution brings to the whole administration of the arbitration with that enforceability in mind, and making sure that best practices are kept and standards are observed. Different centres practice different levels of technical review, from merits observations to very light or soft touch. I can give you an example. ICC does almost a full merits-based review, and they have had their arbitrators have had their awards sent back to be reconsidered by the ICC itself, right? CIPAA, I think you mentioned this. It's not a high number, but it happens. Hong Kong, HKIAC does a very light touch. Their scrutiny is over in less than a week. Back it goes. It's really very light touch to see if all the fundamentals or formalities are observed. Singapore SIAC now has decided, I think it's been hit a few times, so it takes a more sure-footed technical review process. AIAC says it does a very light touch, and by light touch, what do we do? Of course, we make sure that your formalities are observed. the narratives in the way that was set out by CIPAA and Tan Sri just now have been observed. And very importantly, the dates are correct. Parties won the award in USD and you give them in some currency that is not even there, so we make sure the sums add up. And I mean, we make sure that, for me, if you've got 5 issues, you decide the 5 issues, and if you don't want to decide the 5 issues, you explain why. I was very interested in, was it Tan Sri or CIPAA who said about giving the parties the opportunity to come up with the issues. Some come, you give your 10 and they come back with 20 and 25. And we've seen that, and the arbitrators then don't explain which one it is. They've ignored all those and they've started on completely another. So how are you going to try and ensure that that is enforceable? So the technical reviews that we observe at the center is of those formalities, and I personally conduct a technical review because it keeps me on track and helps me find out what's out there. Whether our arbitrators are the best as they say they are, and yes, they are. There are a few who need a little bit of help, and it also allows me to know whether our case counsel are doing, you know, a good job. And we very frequently picked up points which have been missed out or overlooked or inconsistencies. So we offer these recommendations back to the arbitral tribunal, and very frequently they have been approved, adopted, and they come back with their responses before a final award, clean final award is issued. How long does it take? Unfortunately, it took too long. Our goal now is to make sure that it's out inside a month. As best as possible, if we can send out something which comes, a summary determination, I try and send it out in 2 days. So we're expediting our process.
Good. Sorry. Could,
It's all part of the administration costs.
could I just ask Dr. Mary, the award of the Chief Justice of India, you get that award, and your case counsel, or you look at it, hey, that submission doesn't tally with what's been submitted. In that circumstances, what do you do?
We point out and say, we can't find it, please identify where it is. And I will tell you this, I had a case where the arbitrator said, I don't see any proof, but I'm going to give nominal damages, and doesn't say anything. And in the dispositive part, gives a figure with up to sin. You know, when you give nominal damages, it's very unusual that you have it down to, say, 40,302 ringgit and 25 cents. How do you give nominal damages of that order? So we actually had to go back, and we found where it was. It's not nominal damages. It's actually allowing damages on certain special items. So that's a correction. So we send it back. And sometimes there's a lot of toing and froing to the extent that the arbitrators call up and say, can you just look at it? You can just tell your president now, just sign it and approve. So there's a lot of arguments because it's quite people take pride in their award. It's a lot of effort put in. And some arbitrators are offended when they get corrections back on mistakes like, this is an uppercase. Sometimes you use works, capital W, and then somewhere along the line it's small, sometimes it's big. So we just look for consistency, and arbitrators are offended by these, but that's our job. So, Tan Sri, what we'll do is we will send it back as a whole list of recommendations, point it out to you. We've done our job.
The Chief Justice judgment also.
And that is why the CJ of India is not in AIAC panel. All right, I think we have run out of time, unless anybody from the crowd would like to stand up and raise some pressing questions. Thank you for your time and attention. And that's about the time we have. Thank you, everybody.
Okay, thank you.